I am permitted to mention, my lord, item number 153 of today's list, my lord. Amended written statement, my lord.
Sir.
Lordship, if it is not taken up, my lord, then the next date fixed for hearing is on 4/8/2023.
Please indicate that. Hand over the slip.
Lordship,
Yes.
may I be permitted to mentioning, Lordship, this matter was disposed, but still running the matter, running the monthly list.
Running in the monthly list.
Running-
ওটা দেখে নিন তো disposed of running in the monthly list.
Your
Second
Lordship,
note.
if I may kindly
Lordship.
permitted to mention one matter, there is extreme urgency. There is a threat of dispossession of my.
Please hand over the slip mentioning the urgency.
Your Lordship, this is please. I will be dispossessed on 18th. Your Lordship, this is CO number.
Madam, please indicate the mentioning slip.
I have your Lordship. If your Lordship,
Urgency.
I'm being led by Senior Advocate Aniruddha
That is-
Chatterjee. Your
That
Lordship.
is not material. Yes.
Your Lordship, it will take hardly 15 minutes. If you could kindly fix it.
All matters actually to the advocate. Some takes 2 minutes, some
Your
takes
Lordship,
5
there
minutes,
is extreme.
some takes 15
There is
minutes.
extreme urgency because I will be dispossessed.
Madam, please indicate the urgency.
Your Lordship,
Yes.
this-
Item number 162 of today's list, your lordship. This was made.
Upgradation.
It was listed by Mr. Mitra. Your lordship.
Please hand over the
It
slip.
was directed
Lordship,
to be upgraded, your lordship.
matter of
Lordship,
may I be
would
permitted
kindly-
to mention, Your Lordship, expeditious disposal.
Please hand over the slip.
The second
Lordship,
time mentioning, Your
by
Lordship.
Mr. Mitra last week, your lordship had directed it, looking at the urgency, your
Upgrade.
lordship would upgrade the matter. It has not been upgraded, your lordship. Last week, Mr. Surajit Nand Mitra had mentioned it personally, your lordship. There is some urgency, your lordship.
Have you indicate,
Lordship, it has
please
been,
go through the endorsement in the mentioning slip then.
lordship, I have not been able to look into the endorsement.
ওটা কি আগের সপ্তাহে মেনশন করেছে
Mr.
দেখে নিন
Surajit
স্লিপটা
Nand Mitra
দেখিয়ে
had
দিন
personally mentioned it. Same matter.
Sir, I also go personally through all the I indicate,
Lordship, I have not.
so that is why I'm asking you, please go through the endorsement mentioning slip.
I will.
I personally go through each and every mentioning slips.
Lordship,
That much I can assure you.
it has been mentioned many a time.
That is why I'm asking you, please put it in the mentioning slip, the urgency, because I will not be able to remember your submission, oral submission. I go through all the mentioning slips. Yes, Mr.
May I give a prelude and then do that? May I just
Oh, prelude is raised by Mr. Chaudhary. Please indicate what you are trying to say. Please indicate in the mentioning slip, hand over the slip.
just one second. Whole of the
Urgency বলছি যে DRT is not ready to listen to the matter.
said that for each case, give a separate notice, which is contrary to the law elsewhere in the
DRT
country.
fix the matter
As a
on
result,
its
all matters in DRT are getting affected. Matter was removed, matter was adjourned on the pretext of settlement. No payment has been made. I'll say all this and give the slip.
Yes.
You know, this is extremely urgent. Every day, without 5 matters are getting adjourned in the DRT because this is not pending.
Yes, please.
With your Lordship,
Lordship,
with your Lordship.
upgradation, Lordship, expeditious.
Lordship.
No matter, one is one.
Have you indicated that in the list?
Yes.
Consent number in the monthly list and the.
I have.
Lordship, for inclusion of a very urgent matter, Lordship. Lordship,
Under what heading?
Lordship, under the heading, Lordship, hearing, for hearing.
Hearing not possible.
Lordship, kindly.
Madam, not possible now.
Restoration application.
Applications, I have asked you to hand over the
May I be
slip.
permitted for correction of the order, madam? There
Yes,
is
correction.
Your Lordship, upgradation of matter.
Please hand over the slip mentioning the urgency.
Restoration application.
Sir, I have asked you to hand over the slip for applications. Call the list.
Upgrading.
Restoration.
My lord, may I have your lordship's kind leave to mention CO 3571. I have filed an application under Rule 72 of Chapter 7 of the Appellate Side Rules.
Yes, hand over the slip, it will appear under the heading application. Yes.
Any obliged, your lordship.
Listed motion.
My associate will hand it over to the court officer because I'm appearing virtually in person.
It's contested application. Motion. Indicate that. Please indicate that in the mentioning slip, hand over the slip. Yes, call the list.
Lordship, one correction.
Please hand over the slip, madam. You did not mention it individually. Please call the list.
Item number 1.
Item number 1, Lordship. Lordship, item number 1. Lordship, in item number 1.
এই কস্টাইটলা নাম্বার প্রচুর ভুল হচ্ছে একটু দেখে নিন কোথায় লেখা আছে কারেকশন এইখানে দি কস্ট টাইটেল ইন দি অর্ডার ডেটেড ইজ ইনকারেক্ট কস্ট টাইটেলটা আবার দেখতে হবে ওরা কি লেখে দেবাংশু চৌধুরী হ্যাঁ ভুল আছে দেবাংশু চৌধুরী
I beg to mention as very small urgent matter, my lord.
Please hand over the slip. Yes, call the next matter. Please hand over the slip.
My lord.
Yes.
Thank you, my lord.
My lord, serial number 2, I am for the petitioner, my lord.
Yes, this is section 24.
My lord.
For want of
My lord, court is lying vacant, my lord, since long, my lord. That's why I am praying for transfer the case from.
for want of determination, let the. Yes, next.
Number 3.
My lord, I am not here, dear lord, my lord.
Yes, I do not have determination, sir.
My
Yes.
lord. My lord.
My lord, I am appealing for the petitioner, my lord. My lord, I have come before your lordship by way of 24 application.
Section 24, same order. Want of determination, let them go after, please. Call the next matter.
Item number 4.
My lord, item number 4, my lord, I am for the petitioner, my lord. My lord, the senior advocate is just coming in, on.
Notice has been served. There was a direction for service, my lord.
My lord, the other side have been mislead the court in the last hearing, my lord. They have been saying that they are filing a caveat, which is not in the record, my lord. There is no caveat pending.
Lord, it should be in.
My lord, may I permitted to mention, I'm for the petitioner, sorry to submit in late.
That
My
was
lord,
my
what-
instructions. In April, we had filed.
There is no caveat filed. Who has said? Sir, you have said there is no caveat filed.
My lord, may I permit it?
Sir, I think he has said that. Yes, sir. You are making that submission. There is no caveat filed.
And he said that we are misleading the court.
Sir, can you file an affidavit to that effect?
My lord,
You are making a submission before a court of law without going through the records.
my lord, may I permit?
Have you checked up the record whether there is a caveat or not?
My lord, may I?
Sir, you do not know submission.
So I beg to apologize on behalf of my juniors. My lord, the fact remains, yes, I have been instructed on last occasion that no caveat was there.
Sir, please look to this.
Yes, yes. If there is a caveat,
No, please check up. I think this should not happen thereafter. Please check up.
so if there is a caveat in.
No, your juniors
Right.
taking responsibility said
I
there is
think-
no caveat.
I appreciate if the caveat is there.
Perhaps this matter was
Please,
mentioned
please,
without,
please.
my lord, any notice to us.
Please.
He said, we are misleading the court. Your junior said that.
So now who is misleading the court?
Sorry, I beg to be excused, my lord. My lord, if it is the caveat, so the order, but one thing, my lord, kindly appreciate, kindly seize the last order. So we want, well, definitely, if there is a caveat, we want to file the.
You can't move. On the last occasion, they said, I directed you to serve, and today your junior is saying, he's trying to mislead the court.
Sorry to say. What's. My lord, the fact remains here, kindly seize the last order of your lordship.
Yes.
Just definitely, if there is a caveat, we want to just we sub the copy upon the person. It is our duty, definitely true. But my lord, kindly seize, perhaps inadvertently the date has not been fixed when the matter will be taken up. Kindly seize the last order.
Yes.
When the matter will be taken up.
Please start first, then mention. Then it will appear.
And in this context, should I submit one thing?
Yes.
Can it be possible to fix up a date for hearing of?
Please start first, then mention. After serving, it will
Okay,
appear.
sorry.
Ashun. Yes.
On the last occasion, my lord, what I found from the record.
Yes, Mr. Mukherjee.
Now, my lord, what happened, my lord? My client, as a plaintiff, filed a suit for declaration injunction. Now, my lord, I have seen the order passed by the lordship on the last occasion. Now, my lord, if your lordship permit me, my lord, I can say, but the submission or the judgment which was made, if your lordship consider that the order 7 rule 11 is not at all applicable. Why I am telling? My client filed a suit for declaration injunction. Before that, what happened? That my lord, my client admittedly is a co-sharer of the property. Other co-sharer, without intimating my client, now I entered into a development agreement, unregistered development agreement, followed by a power of attorney with some developer. I don't know anything. Subsequently, my lord, that developer, my lord, what happened, my lord, they agreed to transfer the property in favor of some intending purchasers. The developer took money, thereafter did not hand over the possession, not registered the same. That intending purchaser, my lord, moved before the district forum. Before the district forum, I received the summons. I, for the first time, came to learn from the document annexed with the district forum record that there was a development agreement. Then and then I entered appearance and I took the stand that I don't know anything. Because my specific stand is that my other co-sharer did not intimate, my own brother and sister did not intimate me about that development agreement and anything. Therefore, if something happens,
Mukherjee, the issue is whether the suit is the application before the consumer forum is barred under section 24.
Consumer forum already disposed of.
The suit is barred in view of the provisions under section 24. Because 24, before the consumer forum, the matter was decided one way or the other for the consumer forum. So, and there is a bar because if that disputes have been settled one way or the other, for the same reliefs, can you file a suit? That's the only.
Absolutely. I am bowed down by lordship. Absolutely. If the issue has been settled, what is the dispute? If I put this question to myself, what is the dispute before the consumer forum? That an intending purchaser has an agreement with the developer and the developer did not hand over the flat. That's why he filed the proceeding before the district consumer forum. District consumer forum cannot decide whether the person or the intending purchaser.
Who approached before the district consumer forum?
Intending purchaser, not me. Not me. Now,
who are you?
I am the one of the co-sharer without intimating me anything, my lord, that my lord, my other brother and sister intending the development agreement. Now, may I just complete? May I just complete, my lord? I think Mr. Bordon has a very good senior, my lord. Now, what happened, my lord? Admittedly, my lord, against the order of the district forum, I preferred appeal. Now, scope of district forum is limited. That cannot be, my lord. If your lordship consider the prayer relief sought for pleadings of the district forum as well as my suit.
All right, I will hear you. So,
but the question, if your lordship kindly, there is a checkered history, my lord. What happened, my lord, in my specific grievance, my specific.
I will hear you, Mr. Mukherjee. I was of the prima facie view. I've kept it as for orders because your
yesterday there is a judgment delivered by the Honorable Supreme Court, my lord. That, my lord, that in order 7 rule 11 the question of res judicata cannot be decided because if you are
not yesterday, this was delivered quite some time back.
Possibly
April. Mr. Mukherjee, I will hear both of you whether res judicata can be, whether it's barred under.
Possibly, Mr. Bordon is a very good senior, I know, but this is
this is what fell from the bench the other day.
That is different. That is my judgment of Justice Bakshi. This is different.
Yes, see.
This is different.
No, that is Mr. Bordon, Justice Bakshi. This judgment,
that is not applicable.
That is on the footing. That is
order 7 rule 11 use up before the first time.
That is, I asked you to bring this judgment for a different proposition.
No, that is different. What happened in a suit for eviction, my lord?
Mr. Mukherjee, I have asked him to bring this.
That is the reason.
For your favor.
Therefore, he ought to know, my lord, what judgment I am citing. He is arguing before lordship. This is long back.
Because I asked him to bring this judgment, which will go in your favor.
That judgment.
Go in your favor against Mr. Bordon. For that I have asked you. It's not that it's against you.
This is exactly patterned on this point. The judgment which I handed over to your lordship, my lord.
Yes.
Now, my lord, kindly see once Can kindly see once order 7 rule 11? Because initially
I will hear you, Mr. Mukherjee.
this has come before this court earlier also. Order 7 rule 11.
I will hear you. I
But
will hear
I'm
you.
suffering. If I put this question,
Mr. Mukherjee, on the last occasion, I was under the impression whether on this you want to cite judgment. Argument, I have not heard you, so I will hear you. I am fixing this matter.
stay vacate korla thak.
Today, when this matter is taken up for hearing, Yes, Mr. Mukherjee.
And I have served my lord.
You are petitioner or the opposite party?
But kindly remember this matter, my lord. What happened, my lord, before the
Where is the opposite party?
refused. Earlier, 2-3 occasions I came up before this court, refused every time.
All right. So now the records have gone. So no difficulty.
But I
So I'm
have,
directing the civil division 150 capital A to be decided.
I have filed an application regarding maintainability of the 151.
I'm directing that to be decided first. Thereafter, civil division application.
That is because after the amendment of the Code of Civil Procedure, my lord, 115 capital A because my local inspection.
Mr. Mukherjee, I cannot decide that from
No,
here.
I have already filed my late
Yes.
dispute.
Evidence service filed to what is the endorsement?
Because if that
The above observations and directions, CO number. Article number 7. ওইটা লিখে দেবেন refuse upper in spite. Yes.
Petitioner, my lord.
Lordship, I'm sorry to interject, Lordship, but if you would kindly please graciously allow me one mentioning. I was told due to bad weather condition.
No, this is not the time to mention. Yes.
Told by my junior that some caveat has been filed.
There is a caveat has been. You are for the petitioner, Mr. Bhattacharya.
Petitioner.
Yes, please move your application.
Copy of the has not been served upon the caveat. Because
Copy you have not served.
Because I have not.
What is the impugned order, Mr. Bhattacharya?
My lord, impugned order, my lord. My lord, difference between P of the old act and Q and H of the new act, my lord. That was whether H is applicable to the residential purpose.
Mr. Bhattacharya, learned senior advocate.
Because of my
No, thank you, Mr.
deep love like my lord.
This
Yes.
is my application, my lord. Dependent is the petitioner before your lordship.
Yes.
Lord, suit for declaration and recovery of.
Yes, what is the impugned order?
Impugned order, my lord, during the pendency of the suit, two plaintiffs, they are the own brothers. Plaintiff number 3 died on 28th, died on 22nd April 2024. And plaintiff number 5 died on
The
28th,
issue that order 22 rule 4 was allowed
my lord.
without setting aside abatement. The issue that arises for stay till end of November. Yes, call the next matter. Yes, Mr. Haldar.
plaintiff landlord is the petitioner before your lordship.
Yes.
Suit for eviction, my lord, inter alia on the ground of default and reasonable requirement.
Yes.
My lord, the original tenant, my lord, died in December 2008. Now, my lord, after expiry of 5 years, I want to introduce the amendment of section 2G. But that has been rejected by the learned court below only on the ground that no document in support of the income of the husband has not been produced. The tenancy stands in the name of the wife of the in the name of the Leela Devi Nangalia. Leela Devi Nangalia died in December 2018. Now, my lord, by way of amendment, I want to introduce that the husband has no life
The issue
interest.
that arises for consideration is whether
Milord, 10 Milord, I am appearing on lane, Milord. Milord, I am for the petitioner, Milord. Plaintiff is the petitioner, Milord, before your lordship, Milord. Milord, my prayer for police help has been rejected, Milord.
rightly rejected.
Milord, what has happened, Milord? What has happened, Milord?
Injunction or temporary injunction
Interim injunction, Milord.
cannot be done. This application.
Milord, kindly, Milord, kindly, Milord. Milord, the after serving the notice of the opposite party, Milord, they have not appeared, Milord. Defendant chooses not appeared, Milord. And thereafter, Milord, the Milord paragraph, Milord, what paragraph, Milord, kindly come to my page 27, Milord, 27, Milord.
Yes.
27 Milord, at the bottom, Milord. বর্তমানে আদালতের আদেশে সম্পর্কে অবগত হওয়া সত্ত্বেও বিবাদী জোরপূর্বক বাদী শান্তিপূর্ণ দখলে বাধা সৃষ্টি করবেন বলিয়াও বাদী চাষাকার্যে ক্ষয়ক্ষতি করবেন বলিয়া শাসাশুশনি শুরু করলে বাদী অন্য উপায় হইয়া আদালতের আদেশে ইনফরমেশন লইয়া থানায় যাইয়া অন্য পায় হইয়া বারংবার অভিযোগ দায়ের করেন কিন্তু থানা হইতে বাদী কোনরূপ সাহায্য পাইতেছেন না কাইন্ডলি কাম টু দি মিনিট দি ইম্পিউট অর্ডার ওয়ান্স মিনিট কাইন্ডলি কাম টু দি মিনিট কাইন্ডলি
Show me the administrative order of injunction.
Milord, interim order of injunction, Milord. Kindly come to Milord, page 25, Milord.
Page 25. Operating part is page 26.
Operating part, page 26, Milord. Yes,
This
Milord.
want implementation by police help.
Yes, Milord.
Thank you. This application.
Milord, that the ad interim prayer of the plaintiff and the plaintiff is considered allowed ex parte without order that both the parties, plaintiff and defendants, are directed to maintain status quo with regard to nature, character, and possession of the scheduled property as he stands today. Milord, we both will maintain status quo, Milord. Plaintiff as well as the defendant, Milord.
This application under Article 2. Urgent certified copy. Yes, next, what is the certified copy? Yes.
Lordship, for item number 11, my lord, I beg to appear behalf of the petitioner, my lord.
Yes.
My lord, with your lordship's leave, my lord, I beg to move this application for expeditious disposal, my lord, of one title suit, my lord. This title suit is pending from 2018, long back, my lord, 2018 September, my lord. Until that 2025 only, my lord, they have done, my lord, extension, my lord, of the ad interim injunction, my lord. We are defendant number 1, 2, and 3 of the title suit, my lord. My lord, only humble praying, my lord, for expeditious disposal because 2018, 2025, nothing has been proceeded further.
You undertake to appear even if there is a resolution of the local bar association?
No, my lord. I bow down, my lord. This.
There was resolution of the local bar association had to be adjourned. So
Lordship, my lord, that I bow down, my lord. But only humble prayer is, my lord, 2018, 25. We are.
You will take resolutions, you will not appear and come
No, my lord.
For expeditious hearing.
No, my lord. I bow down, my lord. My lord, most humbly, my lord, only humble prayer, my lord. If it can be expeditious, my lord,
This should be stopped. This application under Article 227.
My lord, kindly, my lord, 2008.
Yes, next.
This is my expeditious disposal of the appeal. Appeal pending before the Ranaghat district Ranaghat below. The suit dismissed and appeal has been preferred. I am on the defendant. The appeal is pending for a long period. The appeal before the Ranaghat.
21st of July, it was fixed for hearing. What happened on 21st of July?
Also direction I will give. My last date, my date has been fixed for hearing.
Yes, 21st of July, it is fixed. Trial court records have come. Ashok, this application
Lord, item number 13 is that matter, my lord. On the last occasion, I had item number 43. I had moved, my lord. That is an order passed under 125 proceeding, and the other side 36. Sorry, I stand corrected. And thereafter, my lord, your lordship was kind enough to reject that my application, and that
has been rejected.
Nah, your lordship was rejecting that, about to reject the application. Your lordship had dictated the order. Then, my lord, the wife the other side came up and pleaded before your lordship that they are going to file an application.
Enhancement.
Yes, my lord. That's now. No, that is the reason, my lord. I said at the outset. But yesterday, my lord, at the afternoon, I have received the copy from them, my lord. I have also served them previously. But what I was humbly requesting your lordship, my lord, can it be fixed any day, my lord, next week, my lord, so that I can have all instructions from my client and appraise your lordship, my lord. But kindly
is your PO number?
My is 43, item number 43.
Item number 43.
Let it be fixed on Thursday, not before that, Mala, because I have bereavement in my family. I have.
All right. CO number 2516 of 2025 order record করবেন. The learned advocate appearing for the opposite.
If your lordship commences to take up the matter on Thursday, next Thursday, but Thursday week, then my lord.
After a week. Have you given the other number? Please furnish the other CO number. Yes.
Item number 14. Item number 14 and 15, your lordship, Mr. Shonak Bhattacharya is appearing on behalf of the opposite party.
So what is it?
14 and 15, your lordship.
Yes. Since I'm not inclined to take up this matter on 15, same order. Next. Well, the next matter.
16, I'm for the petitioner, my lord.
Yes.
My lord, I had filed a eviction suit before the civil judge division Warringpur
Yes.
in 2015.
Yes. What is the order you are challenging? Or you want expeditious hearing?
Yes, my lord, and the interlocutory application under Order 6 Rule 17 is also pending since 2020.
What is the next date fixed?
24th of November 2025.
24th of November 2025.
Yes, my lord.
This application under Article 227 of the Constitution.
Item number 17.
May it please your lordship, my lord.
Yes.
I'm appearing on behalf of the applicant, my lord. This revisional application has been preferred against an order passed by a learned arbitrator, my lord, where, my lord, the defect is that the learned arbitrator, my lord, has directed summoning of bank officials, so summoning of witness. That, my lord, is beyond or in excess of jurisdiction under section 27 of the Arbitration and Conciliation Act.
The Arbitration Act to din to. Arbitration Act.
Section 27, my lord. May I please? Court assistance in taking evidence. The arbitral tribunal or a party with the approval of the arbitral tribunal may apply to the court for assistance in taking evidence. The application shall specify the names and address of the parties and the arbitrators, the general nature of the claim and the relief sought, the evidence to be obtained, in particular, the name and address of any person to be heard as witness or expert witness, and a statement.
So according to you, that's not the arbitral tribunal, but it's the court.
Deeply obliged. Because or the arbitral tribunal, my lord, may directly make a representation to the parties for the parties to approach the court.
Yes, either the tribunal or the party.
Yes. So, my lord,
the approval of the tribunal.
May I first take your lordship, my lord, to the prayers which they had made. The claimant, I am a counter claimant.
Show me the order. Show me the order.
Yes, but the order, my lord, page 3 of the order, my lord, we have paginated the order. Page 3 of the order begins. And page 6, my lord, the arbitrator holds. In fact, the arbitrator holds that the bank officials are agreeable to come, but there is no such document or pleading even in the application. That is the other part of my argument under 227, my lord. It begins from last paragraph of page 5. Page 5, last paragraph.
Where is the application?
Yes, my lord. The application begins at page 98. And the prayers, my lord, are at page 102. There are 4 banks, and bank officials of those 4 banks, the arbitrator holds was agreeable to come. But there is no such pleading, neither any document that they are agreeable to come. Well, specifically, they have said, summon the concerned officials from such and such bank to prove bank statement.
There is substance in the argument of the learned advocate for the petitioner, that section 27.
I am appearing led by Mr. Moina Gosmal. He lives on my lord before my lord.
Lordship, I appear on behalf of the opposite party number 1. Lordship, I've been
You are for the
served-
petitioner or? Yes, yes. Please start. No passover business. Please start.
I am for the opposite party number 1.
He's coming. Give short passover.
Lordship, then may I pray for an
Passover
accommodation?
next.
Lordship, then may I pray for an day's accommodation?
Sir, please next.
I'm
Yes.
petitioner, my lord. I've challenged, my lord, an order passed by my lord, the order of injunction passed by my lord the trial court, which is affirmed in misappeal. That order I have challenged. Now, my lord, grounds of this, my lord, there are 2 suits. One suit, prior suit is by me regarding a property. I obtained an order of status quo in respect of the property.
Mr. Banerjee, ad interim refusal by.
Not an interim, my lord. Injunction, my lord, after contestation.
Temporary.
Temporary injunction. Point is very short, my lord. I obtained an injunction in respect of my property with specific boundary. My suit, injunction. Then they filed a suit, similar boundary, same boundary. They filed a suit. They obtained an order that we shall not disturb his possession in respect of the property. Now, after getting.
So both of you are claiming same property.
But the court has come to the finding that the property's holding number is different and the original vendor is different. Line of succession is different. So it's not the same property. You are not prejudiced. That is
What is the order of injunction passed?
Lord, I have been restrained from disturbing his possession and enjoyment over the property. Why I am before your lordship? He has started making a construction of a house in respect of the same property in which I have a status quo in the other suit.
But Mr. Banerjee, I cannot pass any interim order.
I know, kindly but then fix the date because once it goes.
By the order is tuned. The miscellaneous appeal stood.
On that, your lordship will consider the issue of injunction because if they go on making the annex the photographs, kindly see after getting
that I will consider. Yes, call the next matter.
August, September will kindly make it any day in the
August.
Yes, monthly list. Monthly list, it will go down.
Mr. Banerjee, all that are supplementary. Please let it appear first. Yes,
the purpose will be frustrated. Why
will be frustrated? Yes. What is the next?
Any date?
Who is appearing? Who is appearing in the next matter? 20 none appears for the petitioner.
Your lordship, Mr. Shonak Bhattacharya is appearing in this matter for the petitioner.
This, since I'm not inclined to take up this matter.
Matter number 21.
Yes, I'm challenging an order passed by MSME. The MSME Council, what has happened,
Award or the conciliation failed.
Conciliation failed, or that is what I'm on. There are 2 points involved here, conciliation, when it was started, I have taken the point that it involves, a question of fraud.
No caveat is there.
No caveat. Now, I say that it involved a question of fraud and criminal fraud where the supplier has initiated a criminal proceedings.
Yes.
So, according to the Conciliation Act, your lordship will kindly appreciate questions, settlement.
Rai, this is from Baripur Court.
Baripur Court.
Ki dilen?
Durgapur. Durgapur,
No, wrong file has been given.
Oh.
Wrong file.
Yes. Durgapur, 110, But I've got 2 points, kindly appreciate. One is an easier point, but there is a bigger point which I want to argue before your lordship. One is, conciliation of criminal proceedings cannot be taken or undertaken by any conciliator, one. And second is, my lord, when this,
which is the order which you are challenging, 15th of May,
110, 15th of
15th of May.
My lord.
Please give me a minute.
Yes. That's a bit of conciliation act though.
So conciliation terminated, then referred to arbitration.
I am saying, my lord, two things.
Arbitration cannot be done. Fraud.
Conciliation also cannot be done.
But did you take this point before?
That is why I specifically said so. My lord, when I put in my reply, my lord, the council said that it will decide on this point.
Where is that order?
That is not there.
Then, Mr. I can't.
To that. Dear Lordship will have a better point.
I can give you liberty to approach the council with that you have said this. The council said that date has been fixed for that. I cannot decide it from here. That issue.
It has not been fixed.
So you said that the council, the facilitation council said that that point will be decided hard on the next day.
Well, it did not. So next day it only passes an order.
That I appreciate that.
At the point, if your Lordship really looks into it, but conciliation, your Lordship knows MSME has incorporated in itself the Conciliation Act.
MSME Act আছে নেই.
I have.
Yes.
It is out of chapter. Kindly see section 16.
Mr. Rai, can it be decided in the absence of the other side?
But I need a stay. And I'll make it a privacy case. Very important, my lord. I'll make it a clear
section.
My lord, section is, my lord, 16, my lord. 18, sorry, 18, my lord.
Yes.
চোখে কিছুই দেখছি না ওরে মানে সিজ 18 এটা কোনটা হ্যাঁ মানে কাইন্ডলি সিজ পুরোটা দিয়েছো যাচ্ছে আচ্ছা তাহলে দেখ হ্যাঁ মানে কাইন্ডলি সিজ 18(2) on receipt of a reference of the council shall either itself conduct conciliation in the matter or seek the assistance of any institution. I am on that matter for conducting conciliation. The provisions of section 65 to 81 of the arbitration conciliation shall apply to such a dispute as if the conciliation was initiated on a part 3. What has got that?
No, section 18 subsection
2.
Yes, 2. Please place 2.
Well, I must have given your lordship the new act, my lord. I'll have to give you a
That is why it's not matching.
I'll point this out, my lord. My learned advocate, my lord, he was appearing, he had taken this point also, that conciliation is no more there because of this act.
That is why I was.
Now what has happened, my lord? All
mediation, it's mediation.
My lord, all book companies have incorporated mediation, but this has not yet been notified.
What has not been notified?
Mediation Act, the section by which this.
The conduct of the mediation shall be as per the provisions.
It is section 60.
Then what is the effect of this?
So, my lord, the original act remains. What has not been amended, my lord, I am handing over, my lord. And that is what they also followed.
Section 18.
18.
Yes, please place that. ওই বইটা ফেরত দিয়ে দিন নাহলে থেকে যাবে yes
my lord, has got 18(2).
Yes,
my lord, it incorporates section 65 to 81.
Yes.
Now, my lord, kindly takes section 65 to 81. But I'm trying to take an easier route out.
Mr. Rai, this is if the conciliation is proceeded with. Now has not been proceeded with, it's been terminated. So according to you, that dispute could not have been decided by way of conciliation. So in effect, how can you be aggrieved? Because this was terminated, not a decision on merits.
I'm saying the termination itself is wrong. Because there is a provision under this act of conciliation, how termination can take place.
Where is that?
That is what I'm trying to show you, Lordship. As I said, I'll try and take an easier route out.
Yes, yes.
And when they come, I'll try and establish another point.
Yes.
Kindly takes section ওল্ডটা দিয়েছো তো?
That's the old book.
মানে your lordship has the old book. মানে
You have given me the old book.
No,
New
no.
book were given, taken back.
Oh, no,
Now
no.
you have given
Now
me-
I'm
I
asking you
cannot understand what is going on, Mr. Rai.
point out Malad again, Malad. Malad, the Mediation Act.
So on a lighter note, don't take it
No, no,
seriously.
because now the Arbitration Act, Malad,
Yes.
has also been amended,
Yes.
but that has not been given
So
effect.
termination is under what provision of
No,
this
that-
conciliation? That is under the Arbitration Act.
Conciliation Act.
Yes.
Arbitration Conciliation Act. Malad, just gives me 1 minute's time, Malad. Arbitration Conciliation Act has also undergone or supposed to undergo a amendment by the Mediation Act, but that has also not been, Malad,
Because that has not been.
notified. So, Malad, the conciliation part is there, Malad. If your lordship kindly looks into section 76, Malad.
Section 76.
Yes, Malad.
Mr. Rai, what are you doing? You have given me a book.
Malad, I cannot give
After 62, I find 82.
Malad, just after 82, Malad, your lordship will find it, Malad.
Then it's 83. Oh, below.
But I'm sorry, Malad, because I've incorporated the amendment
Section,
which has never been notified.
section.
76, Malad.
Yes.
The conciliation proceeding shall be terminated by signing of the settlement agreement. It is not there. By written declaration of the conciliator after consulting with the parties to the effect that further efforts at conciliation are no longer justified on the date of declaration. Not there. By written declaration of the parties addressed to the conciliator. That is also not there. By a written declaration of a party to the other party and the conciliator if appointed to the effect that the conciliation body are terminated on the date of. None of these have been given.
So according to you, the termination is bad.
Itself is bad. On the face of it, Malad.
Mr. Rai, can you take these 2 points? Once you say conciliation could not have been entered into, and then you say termination is bad.
Malad, why
When
I'm
you say termination is bad,
I'll
can you
point
now
out-
say no, it could not have been?
I'll point out why, Malad. I can. Because, Malad, first thing is the question of the conciliation being maintainable would have been before the conciliator.
Yes.
Now the conciliator would have had to pass an order, which would be, Malad, in the nature of, Malad, it would have been, if allowed, under B, 76B, after consulting with the parties. That would have been the case of
So
termination.
according to you, that termination is itself bad since it is not in accordance with section
Yes.
76.
Yes. And accordingly, Malad, if I can, Malad, if the conciliator hears this out, of conciliation not being, sorry, Malad, a case of fraud cannot be dealt with in conciliation, then it has to apply its mind. It's conciliator is not a stamping authority, Malad. It will be there and
But,
Malad,
Mr. Rai, even if, so according to you, the conciliation must fail. It could not go on. So it's then the arbitration.
Malad, the
It's
entire
then the arbitration. Arbitration, Mr. Rai, there are 2 line of decisions. One says fraud can be decided, other says.
Malad, may I, Malad? 2 things, Malad. That is where I will argue before your lordship when the other side comes. If your lordship passes an order in my favor. Why I am saying this, Malad? The initiation of an MSME application is by conciliation.
Yes.
So, Malad, if the conciliation is not available,
Arbitration
then
could not
it
have been
cannot
referred
go-
to.
Then it cannot go to arbitration. Because, Malad, 18.3 specifies only on conciliation coming to an end,
After termination,
it has to go to arbitration.
so if 76 is not applicable, could not have been
Gone to arbitration.
under 77.
Yes. That is once it ends, then, Malad, the other provisions of Arbitration Act gets incorporated. That is why, Malad, I am before your lordship.
Show me that reasoning why it was terminated.
Malad,
That part, page 110.
Yes, yes, Malad.
What is the reasons why?
It says that we come to a conclusion. Please, the conciliation process in the referred matter duly held has been terminated without any settlement between the parties. Now the council is hereby initiating the arbitration process.
The issue that arises
record will come up in a contempt, my lord.
Sir, right, it's not that contempt is apprised, what is the effect of that? Because you have a duty also to.
But I'll point out, my lord.
May not be that they are not that expert, so.
My lord, my lord, your lordship knows that I have been helping them out for quite some time.
That is why I'm
The
saying
vigilance.
content may not help because you have.
But I'm sure, my lord, they will not take steps. I'm grateful, my lord. Very good.
Yes. Password to take
Item number 18.
Yes.
22, my lord.
18. Yes,
My
who
lord,
is appealing for
interesting
submission?
questions call for your lordship's consideration. Briefটা কোথায়? Jokers or what?
Yes.
Eviction suit. An impleadment application stands rejected in an eviction suit. I'll tell your lordship.
For the petitioner.
I am for the petitioner.
Please change your side, Mr.
I'm so sorry.
I was thinking you are opposing that, and you have started with that. That has been rejected.
No, nice.
Yes.
I'll tell your lordship.
In an eviction suit, an application for impleadment has been rejected.
Now,
rightly rejected.
I'll tell your lordship.
The moment you started, cannot be. Who are you? Sir,
I am the co-owner who has not given consent to the eviction proceedings. And my lord, the admitted position is this is the transferee landlord. The transferee landlord has now set up a case, so he has derived his title or interest in the property from his predecessor. Now, the predecessor admittedly had half share, and the tenant used to pay rent of half share to the predecessor.
It's a undivided.
My lord,
it's an
undivided property. Admittedly, an undivided property.
No, lordship.
No, my lord, the moment we say he refers to a partition of 1952. Now, admittedly, the parties from whom he has purchased this partition has never been given effect to. So the partition has to be by metes and bounds for the tenancy to divide or devolve upon any one allotment. Admittedly, the applicant, which is the other owner, half share owner, he makes out a case that I receive half rent.
You entered into an arrangement with the tenant, Mr. Bose.
No. Even if I have, let's put it there. So he's my tenant, I get rent from him. So he was
you collect rent from him.
But the question is that
nobody is stopping you.
What you will see, he's a transferee landlord. He purchases the property and files a suit for eviction.
Mr.
Now, you cannot, my lord, if today lordship will kindly appreciate if the suit is decreed. If the suit is decreed,
yes.
So the tenant will be
yes.
Now it will not affect my rights. So I am not going to get share rent, and I don't have consent. Admitted position, I'll just show from his conveyance only. Nothing more, nothing less.
Mr. Bose, what you are trying to agitate is a dispute between co-sharers. Is a dispute between co-sharers whether the scope of
dispute.
Yes.
I'll tell you.
Suppose you are saying that I am a co-sharer.
Yes.
So I have a right to collect over the rent from the tenant. He will say, yes, I have a right to collect rent from that tenant. He says, I have a right to evict. You say, no, you do not have any right to evict. So it will be a suit between a landlord and a tenant will be converted to a suit between the co-sharers. Whether that is permissible under Order 1 Rule 10.
My issue is, my question is that, is a suit without the consent admitted? Now, if the co-share issue is dispute.
Please satisfy me on this.
Yes.
Whether a suit for eviction intercept between a landlord, a person claiming to be a landlord.
Yes.
So it's a suit under Section 6 of the West Bengal Premises Tax.
It is.
He did not even prove ownership as per the new law.
No. If you admit that I am the owner of half share.
Mr. Bose, he did not prove even the ownership. Landlord. Yes. So landlord, so this dispute between the landlord and a tenant, whether it can be enlarged to bring within its fold the intercept disputes between the co-sharers.
No, the question is that locus now two judgments. My lord, my lord, India umbrella, which has been recently followed by the Supreme Court.
Yes.
Kindly take these two judgments. না তুমি বলবে কেন টেনশন করছো কেন?
Lordship, the exact ground that your Lordship has taken is the ground on which the trial court has dismissed the application, relying on a Supreme Court judgment of 2018, which covers it.
Sir, you will be having your turn. Let Mr. Bose exhaust himself first.
My lord, kindly first take, my lord, 2017 SCC Online Supreme Court 2133. Before that, my lord, may I show your lordship, my lord, one relevant fact is, my lord, only I will show, my lord, 2 paragraphs. I will show your lordship the plaint and his conveyance on the basis of which he claims to be the landlord.
Not yet entered into the merits.
So I am on that.
The basic fundamental.
Yes. So, my lord,
please satisfy me on the fundamental.
in order to appreciate the fundamental,
can be converted into a title suit inter se between the co-sharers. Please satisfy me on that.
No, my lord, what I am on is,
by allowing an application under Order 1 Rule 10, the scope of the suit can be enlarged.
My lord, if I may look at the query posed by your lordship a little differently. Here is a eviction suit admittedly filed by one co-owner without the consent of the other co-owner. Issue is that, my lord, can the suit proceed without impeding the other co-owner? And, my lord, this is the issue, and if it can proceed or not. My lord, on this perspective, my lord, kindly take 2017 SCC Online SC 2133. Has it been given to your lordship, my lord? DHO, SCC Online ta? Jokers or what? Where is SCC Online?
2017?
Well, 2017 SCC Online Supreme Court 2133.
2133, yes. Give me a copy.
Kindly allow me, my lord. Yes, my lord. My lord, this refers to the judgment in the case of India Umbrella. My lord, kindly take paragraph 2 of this judgment. The petitioners are 2 out of 3 co-owners who had instituted a suit for eviction of the respondent number 1 tenant. The third co-owner, who is the defendant number 2 in the suit, in his written statement, objected to the eviction and explicitly stated that the suit is without his consent. The trial court, while considering the application under Order 7 Rule 11, filed by the defendant number 2, thought it proper to hold that the objection raised with regard to maintainability should be decided in course of the trial. In appeal, the High Court took a different view, holding that the suit to be not maintainable. Hence, these petitions of special leave in appeal challenged by the order. Now, my lord, your lordship will kindly take the para 5 ones. The issue of maintainability of a suit in the facts noticed above apparently has not fallen for consideration before this court. What has been decided, and it will not be necessary to refer to the long line of cases on the point, is that regard to maintainability of a suit by a co-owner in the absence of any objection of another co-owner, such a suit has been held to be maintainable. What would be the position if a co-owner objects, as in the present case, is the question that falls for answer in the present petition. Then, my lord, your lordship will see India Umbrella has been referred.
Paragraph, yes.
Para 9 and para 9.
Thereafter, paragraph 8, you will not be placing, Mr.
Yes, of course, my lord. The very concept of co-ownership in the absence of any partition would militate against the maintainability of the suit for eviction against a tenant, where the tenant is admittedly in possession of the property which is owned by the co-owner who objects to the eviction. The decision in Patna High Court, my lord, this is referred. My lord, now kindly take paragraph 10. It disagrees with Patna High Court. Having read then considered the judgment of the full bench of the Patna High Court, we are unable to agree with the views expressed therein. Well, Patna High Court has exactly expressed this view. The Patna High Court seems to have taken into account the power of veto which would be vested in a co-owner if a suit for eviction to which he objects is held to be not maintainable. The issue with regard to partition, which is an option open to the co-owners who seek eviction, was sought to be answered by the High Court by holding the aforesaid remedy to be cumbersome. When the law provides a remedy which the aggrieved party can avail of, the same cannot in our considered view be ignored.
So Patna view was not accepted.
No. And then it says, well, it affirms the High Court's view that the suit is not maintainable. Kindly take paragraph 11. For the aforesaid reason, we are inclined to take the view that the decision rendered by the High Court in first appeal is correct. We therefore affirm the said decision.
Yes.
Now, my lord, what I was respectfully submitting, my lord, in this perspective, my lord, one paragraph, and only one paragraph. My lord, kindly take the plaint once, my lord.
Do you have the decision of India Umbrella Manufacturing?
Yes, I do. But it says, my lord, kindly take India Umbrella does not answer this. If your lordship takes para 6 months,
yes,
India Umbrella. The closest decision on the point in the case is India Umbrella, which, however, does not answer the question fully, as the objection of the co-owner in India Umbrella was in course of the trial of the suit and a situation where the suit property has changed hands. So, well, there what happened in India Umbrella, well, what had happened is initially the suit was filed by all the co-owners. During the pendency of the suit, one co-sharer sold his share to a third party. So that third party Impleadment said that I do not have consent to proceed with the eviction proceeding. So in India Umbrella, it was held that at the initiation or at the inception when the suit was filed, since the consent was there of all the landlords, that is sufficient. So that is why it says that this is not the answer so far as India Umbrella is concerned. India. Now, my lord, kindly take only one paragraph from the plaint. My lord, kindly take the plaint which starts at page 14. Lord, kindly take paragraph 2. Well, kindly take paragraph 2 with page 14 months. Is your lordship looking at India Umbrella? Yes, para 6 of India Umbrella. Now, my lord, kindly take once page 14.
Page?
No, your lordship looking at India Umbrella.
Yes.
Well, paragraph 6. That is why it says that, my lord, here that same thing had happened. It says it cannot withdraw its consent midway in the suit. That was India Umbrella. But here is a case that there was no consent of the landlord.
Photocopy of this judgment.
Yes, I will, my lord. Certainly, my lord. My lord, kindly now take, I'll just take the trouble of looking at one paragraph in the plaint. My lord, the plaint starts at page 14.
Any decision you want to cite, Mr. Any other decision you want to cite?
On
any point? So that we can first finish the legal issues, then we can go to the fact.
Yes, my lord. My lord, the
on what?
My lord, proper and necessary party. I need not tell you, lordship. But proper and necessary party issue.
If you want to, you can cite, Mr. Bose. You can cite one decision if you want.
My lord, the proper and necessary party, the new judgment which has come. I tell you, lordship.
Need not multiply. You can cite.
No, I'll just only one.
According to you, maybe
only one. My lord, this because this refers to Mumbai International, which is the main. Well, this is the judgment. I don't have a copy right now. I have just
give me the citation and
I'll just give it to your lordship, my lord. This is JN Real Estate versus Shailendra Pradhan. This was, my lord, as Justice Chandrachud is to say, we should all refer to INSC now. Well, this is 2025 INSC 611.
2025 INSC
611. It has not yet been reported because this is a judgment of, I think, sometime end May 2025.
All right. So this is on
necessary party. Now, my lord, here, your lordship will kindly take.
Yes. Now, which paragraph?
My lord, it follows para 23.
Yes, please place that.
My lord, para 22 and 23. My lord, that Mumbai International explains the import of the expression necessary party and proper party. Well, the quoted portion of Mumbai International, my lord, which is 2010.
Place only the relevant portion.
Yes, yes, only that portion, my lord. A necessary party is a person who ought to have been joined as a party and in whose absence no effective decree could be passed at all by the court. If a necessary party is not impleaded, the suit itself is liable to be dismissed. A proper party is a party who, though not a necessary party, is a person whose presence would enable the court to complete
Adjudication of the complete adjudication of the suit.
adequately adjudicate upon all matters in dispute in the suit, though he need not be a person in favor of or against whom the decree is to be made. If a person is
What we
not
call as pro forma parties.
If a person is not found to be a proper and necessary party, the court has no jurisdiction to implead him. So this is now on this principle now, my lord.
So according to you, the other co-owner is the necessary party.
He has made out that case in the plaint
Show me
itself. Now, my lord, kindly come to plaint.
Yes.
Page 14.
Yes.
What he does is that he, for his convenience, my lord, of course, he is entitled to as a plaintiff dominus litis. Now, kindly, my lord, take the first paragraph in the plaint. By a registered indenture of conveyance in 2021, the plaintiff purchased from, my lord, kindly make a note of this name, Pushpa Devi Jhawar, the divided half portion of the land, A and B, lot A and B. Very well, my lord.
So he has purchased according to him.
According to him, very well. And my lord, kindly now take paragraph 2.
Defendant is a tenant in lot A.
Kindly see, was an existing monthly tenant in respect of one room on the ground floor. Kindly make a note of the rent. Lastly, paying rent of 5,500 per month according to the English calendar month. Now, my lord, now let's take this conveyance once. My lord, kindly take the conveyance which starts at page 72. And my lord, kindly come to page 82. Your lordship has seen 5,500 is the last paid rent. Now, my lord, your lordship will see there is a list of tenants which forms a part of the deed of conveyance.
Yes.
My lord, kindly take the name, the first name, which is the defendant in the suit. Kanayalal Chawla, Karan Chawla, kindly see ground, occupation ground since 1998. Now, my lord, kindly see the rent.
2750.
Yes, which is half of 5,500. So you have, at the time when you have purchased the property, your predecessor was a co-owner and he used to get half rent. So she admits that she used to get half rent. So this is a joint landlord. Now, my lord, here when I file an application seeking to be impleaded, I say that this partition has never been given effect to, and I produce a deposition made by none other than their own predecessor in a suit in 1972 that the partition has never been given effect to and it remains to be an undivided property. Court proceeds
when this was given, when this
in my application for impleadment, I disclose by way of evidence, well, documentary evidence, a deposition given by this Pushpa Devi Jhawar. The Pushpa Devi Jhawar, my lord, got
on when?
My lord,
this is the date of that deposition.
1972. That this all along is a joint property and this property has never been divided in metes and bounds.
Yes.
Now, my lord, kindly have a look at my application, what I say in my application. My application starts at page 44.
Yes.
Well, there is one more issue that will not trouble your lordship now. Well, kindly take paragraph 7. at page 46 of the application for impleadment. Well, kindly see, Mohanlal Jhawar is the person from whom Pushpa Devi Jhawar derived her title. And there was a trust. But there is another issue whether Pushpa Devi could have sold. That's a different issue. I'm not troubling your lordship because Pushpa Devi was a trustee and the other half owner was a trust.
Mr. Bose, these are the interstate disputes between
I am only restricted myself to joint landlord. I am my tenant.
Disputes, whether his vendor had a right to sell, whether that was.
I'm just saying
interstate disputes.
Right. So I have restricted my application to that. I have not given consent for eviction of my tenant. It is a joint tenancy. I am a joint landlord, admitted position. So can half share undivided owner file a suit without impleading me when I have said I am not given consent? So this is so I have to be impleaded in that party in eviction proceeding. If the eviction happens, tenant goes, he suffers a decree, he will be evicted. That's my right in the property to get benefit out of my property.
Yes. So it's a right in the property. Thank you.
Right in the property. So my right in the property you are taking away by filing a suit for eviction.
That will be decided in a suit.
No, but in a suit, no. So if you have to suit,
purpose will be served by adding you if that issue cannot be decided in the suit.
The question is that whether
your
the
right
suit is maintainable.
So your right in the property is being affected. So if that right of yours in respect of an immovable property is being affected, whether that can be a ground for you being added in a suit for eviction.
No, if the suit, if he gets the decree, I say that you don't have a right to pursue the suit. You must have a right in law to pursue a suit. Well, had it been any other suit, I would have understood. In a suit for eviction against my tenant, I accept him as a tenant. So now the moment I say that I don't have consent.
Mr. Bose, this is the sum and substance that the property, the person, the tenant, is a tenant in respect of an undivided property.
Right.
And you have a right to collect rent.
No. Admitted position is that he used to give half rent.
Yes, so you have a right to collect rent.
Right.
And that also is being evident from some of the documents or the basic document by virtue of which the plaintiff is claiming title in respect of the property. So, and you do not want eviction of a tenant.
Right.
So whether without you, this suit for eviction can proceed.
Can proceed or not.
Anything more, Mr.
Nothing. My lord, I'll just show you, lordship, what I have said in my application. That's all.
Yes, paragraph. Which paragraph?
Para 7. Para 7.
Para 7, page?
My lord, page 46. My application starts at page 44, page 46.
Paragraph 7.
Your petitioner states that Mohanlal Jhawar, son of such and such, deposed in title suit number 194 of 1970. In his evidence, he categorically stated that the collection of rent was being conducted on mutual arrangement on the ground, first, second, the entire property by himself and 50% to Kanayalal Jhawar, which is the present applicant's share.
Seems to have purchased from Pushpa Devi.
No, so Pushpa Devi got the title from Mohanlal. Then, my lord, kindly take para 8.
All right.
Petitioner said that the premises such and such is not partition. The deed of partition was never given effect to.
Yes.
So with this lot B, lot A, this is never been given effect to. Partition has to be by metes and bounds.
So yes, so your submission is that is the tenant in respect of an undivided property.
Yes.
You are collecting rents.
Yes.
From the property. So whether the suit, that's the only issue.
Yes.
Whether the suit can proceed in your absence.
In the absence of the admitted other co-owner
who
is also a landlord.
Yes, yes.
This is a limited issue. This is a limited issue.
I'm coming after 5 minutes.
Very well.
Mr. Bose, can you give me a copy of this?
I will.
लोग आसे की बोलो लोग Because I think he has cited before the learned.
Yes.
He wants to place it in his own way.
Of course. He has every right to.
You can give a reply on that.
Yes, just 10 seconds on that.
Yes.
So first, I would like to just show 3 dates. Your Lordship, my suit was filed on March 2022. That Your Lordship will find the plaint starts at page 14. The
filed on March 2022.
March 2022. Your Lordship will find the affirmation at page 23. So I filed the suit for eviction. Thereafter, the tenant filed the suit making the applicant herein and the plaintiff in the eviction suit a party. That is filed in July 2022 as a repercussion. That Your Lordship will find at page 28. And the only relief sought for is that do not disturb my possession. Page 28 kindly takes up, Your Lordship. This is a title suit filed by the tenant, wherein the applicant is the defendant number 2 and the plaintiff in the eviction suit is the defendant number 11.
Yes.
Thereafter, this application under Order 1 Rule 10 has been filed after a lapse of 2 years in 2024, when they were aware of this pendency of the eviction suit. This Your Lordship will find at page 44 is the application, page 48 is the affirmation. Your Lordship, just to show that the intervener or the applicant is nothing but a setup by the tenant in order to obstruct his eviction.
That when Mr. Bose started, I got an impression. I asked him that question.
Agree. Now, Your Lordship, the second point is the
Mr. Bose will agree even if he is evicted, he will accommodate the tenant in his portion.
My portion. There is no my portion. It's an undivided property. Had it been my portion, his portion, that the way court proceeded, the demarcated portion. Where did it get the demarcation from? Where is the demarcation? There is no demarcation by meets and bounds.
Mr. Bose, lighter note.
No, well, at this lighter note, these lighter notes is great relevance. So we take a cue from these lighter notes, and apply this to the case. Your Lordship will find the answer there.
Yes.
Lordship, second is, my contention is that this is a suit which has been partitioned by meets and bounds by way of a registered deed. And I have purchased the partitioned property, lot A and B, by way of a registered deed of conveyance dated 25th of January 2021, which is at page 72, which derives how the title has flown and that it was partitioned. If Your Lordship sees page 74.
74 is the deed of conveyance.
72, the deed of conveyance starts from where I have purchased it. 74, clause D, by deed of a partition dated 3rd April 1959, made by Kanhaiya Lal Jhawar, Magi Devi Jhawar and Mohan Lal Jhawar, registered at the office of such and such. There in itself, the lots were demarcated. Your Lordship will see lot A, lot B, lot C, lot D.
Yes.
Thereafter, Your Lordship, in 31st of March 1965, clause E, Your Lordship will find there was another registered deed wherein Mohan Lal Jhawar transferred the lot, who my learned friend is claiming had deposed in a suit in 2001, whereas he himself had parted with it in 1965 by way of a registered deed. Now, Your Lordship, the fact that this is a partition property will also be evident from the KMC assessment slips. There are separate assessment slips for each lot. Kindly takes up page 89 and 90, Your Lordship. Lordship will see page 89. Lordship will see left hand side owner information, Prabhat Jhawar. Lordship will see assessee number is 144 on the last. And the premises number is P18, street name, CIT scheme number, such and such. 890, Your Lordship will see there is a different assessee number, 132. So for the same premises, there are different assessee numbers because it has been partitioned by meets and bounds, and therefore there are separate assessee numbers.
Yes.
Now, Your Lordship, with regard to the enlargement of the scope, as Your Lordship has correctly pointed out, Your Lordship may kindly consider page 2018 2 SCC 352. So on the exact same point, ejectment suit, civil revision application under Order 1 Rule 10, ejectment, this was the party claimed to be a co-owner. This was held by the Supreme Court, which is 2018 to SEC 352. Your Lordship will kindly take the facts of the case. This appeal is directed from against the final judgment and order dated such and such passed by the High Court of Kolkata in CO number such and such, whereby the High Court allowed the application filed by the respondent number 1 herein and reversed the judgment and order dated such and such passed by the Judge Small Causes Court Kolkata in ejectment.
Paragraph you are placing?
Your Lordship, the first paragraph.
Yes.
Very first paragraph. This also a ejectment suit, application under order 1 rule 10, rejected, revision filed before this High Court. The High Court reversed it. It was gone into an SLP was preferred before the Supreme Court. The Supreme Court held that the trial court's judgment is correct. But you will see the similar application, Small Causes Court, ejectment suit number such and such, wherein the trial court dismissed the application filed by the respondent number 1 under order 1 rule 22 civil procedure for pleading as the plaintiff in the pending ejectment suit.
So you will be relying upon subparagraphs of paragraph 11 and paragraph 13.
Lordship.
These are the two paragraphs.
Wherein your Lordship 11.3 specifically states. Lordship.
11.3 in particular, all the subparagraphs and paragraph 13.
Great, Your Lordship. Those are my submissions, Your Lordship. That in
Not anything more.
Lordship. Lordship, in an ejectment suit, my learned friend cannot come in and enlarge the scope of an ejectment suit to a title suit. And Your Lordship, if my learned friend has any grievance, he is free to file a title suit. He is aware of the deed of.
Can you give me a photocopy of this?
Lordship, I will supply a photocopy. This matter was only served on us on 14th, so Your Lordship, I have already taken a copy.
Yes, anything more?
No, Your Lordship, these are, Your Lordship,
this was the judgment which was cited before the learned trial.
Lordship. And if Your Lordship takes the impugned order, Your Lordship, some infirmity must be shown in the impugned order for it to be set aside. Lordship, kindly sees the impugned order. The reasoning starts from page 4.
Yes.
Your Lordship will see in the middle of the paragraph. I do not want to burden Your Lordship with the entirety of it. Clearly, the disputes, as Your Lordship found it in the middle of the paragraph of the last paragraph.
Clearly, the disputes
raised by the applicant as a bearing on the legality of the partition that had taken place in the year 1959 and the right, title, and interest of the plaintiff flowing from such partition through the deed of conveyance. Such dispute cannot be adjudicated in an eviction suit filed against a tenant within the scope and ambit of the provisions contained in the West Bengal Premises Tenancy Act, which deals with or regulates tenancy of premises, primarily focusing on the rights of the landlords and tenants involving fixation of rent, eviction, protection of tenants from eviction, and the procedure in connection thereof. In the present context, the nature of dispute raised by the applicant herein can only be decided in a title suit. The ratio of the decision laid down by the Honorable Court in 2018-2, which says it fairly squarely falls in the facts of the case.
Yes. Anything more?
Lordship, just one factual distinction, if Your Lordship allows me. The rent that my learned friend has, learned senior friend has pointed out that 5,500 and 2,750, Your Lordship will kindly take, though the annexure of the plaint is not here, Your Lordship kindly takes paragraph page 18, Your Lordship, of the plaint.
Yes.
Your Lordship, we came to know because at the time of entering into the deed of conveyance, we were aware that the rent is 2,750. When we issue a notice to the tenant writes back to us at page 18, Your Lordship, the defendant, we have included the letter, the defendant relied. Your Lordship, the first paragraph replied of the said notice to quit by his letter dated 23rd of January 2022. Lordship, in this letter, we came to know that the rent is not actually 2,750 but 5,500. But Your Lordship, the plaint does not contain its annexure, so I am not in a position to place it before Your Lordship.
Anything more?
No, Your Lordship, those are my submissions.
Only one thing, my question to you is,
Lordship,
kindly come to page 89 and 90.
Lordship,
you have pointed out two SSC numbers.
Lordship,
but the name of the owner is same.
Lordship, I am the owner for both the portions, Lot A and Lot B. Your Lordship, that is there in my deed of conveyance.
Yes.
I have there, the property is divided into 4 lots, A, B, C, and D. I am the owner of A and B, both. That's why my name is reflected.
You are in both?
Yes, Your Lordship. I have purchased both Lot A and Lot B.
All right. Yes, Mr. Bose, anything in reply?
My lord.
Not on facts.
No, not on facts. Para 5 of 2008 judgment.
Lordship, I've got
18 judgment. 18. Para 5.
A copy for Your Lordship.
Of this.
This is the distinguishing feature between the 2017 SCC online and the 2018 judgment. Kindly take 2018 para 5. In this ejectment suit, respondent number 1 herein filed an application under Order 1 Rule 10, praying therein that he may be allowed to become a co-plaintiff along with the appellants. Respondent number 1 sought his impleadment, alleging that he is a member of the appellant's family and being so has a right, title and interest not only in the suit premises but also in the other family properties as one of the co-owners. It is essential on these allegations and with a view to protect his interest in the suit premises, respondent number 1 sought his impleadment in the suit. And this is why, my lord, the Supreme Court at paragraph 11, subparagraphs 11.6.
And according to you, you want your impleadment as a defendant.
As a defendant. And I say, here was a case where the plaintiff had consent to the suit for eviction. Despite that, wanted to be impleaded. That's why that 11.6 Supreme Court says that if there are co-owners and landlords of the suit premises, then any co-owner or landlord can maintain a suit for eviction. Undisputed proposition. But when there is when a consent is not there of a co-owner, issue is there. That is the answer in 2017. SCC online. That the answer comes there. If your lordship will see that Mangal Builders judgment, Mangal Builder says that. And High Court had held that and that has been affirmed. That if there is an objection from a co-owner, eviction suit is not maintainable. And he has to be impleaded as a party.
Anything more, Mr. Ghosh?
These are. May have your lordship's kind leave, my lord. Great.
Or the Yes, call the next matter.
Your lordship, I am praying for 1 week of adjournment. We could not ascertain the LCR advocate.
What is LCR, sir?
Advocate as per lower court record.
You want 1 week's time? Give me one day time. Not today.
Okay. Thank you, your lordship.
Yes. Call the next matter.
Item number 23.
In this matter, Mr. Shankar Prasad Dalabachi is appearing on behalf of the petitioner. He is coming, my lord, praying for short pass over, lordship. I am not with this matter, lordship.
Yes, pass over.
Number 24.
Madam, Mr. Sridhar Naik is appearing for the petitioner. He is engaged in court number 15. So I am praying for not this week on his behalf.
Yes, what is this matter about?
Lordship, I am not in this record.
Since on the prayer of the learned advocate for the Yes.
It is that matter of Milord. Yes. Mr. Ghosh, Milord,
provided me, my lord, the judgment which Mr. Ghosh wants to rely upon.
Yes.
My lord, I will place my case showing those judgment itself.
Yes.
Kindly takes up, my lord, now the plaint. I have shown before your lordship. Lord, kindly takes up volume 2.
Yes.
Page 315.
315.
315.
Yes.
The conspectus, my lord, may I just tell your lordship, the conspectus of the present suit is that there are two, my lord, NIT, notice inviting tender.
Yes.
In respect of the first notice inviting tender, my lord, where the present defendant number 1 is being selected, my lord, as a first bidder, he, my lord, issued work order, work done. Thereafter, successive extension was being done. My lord, there is dispute, my lord, with regard to that extension. Last extension, my client, defendant number 1, did not, my lord, availed of. So, my lord, ultimately, that tender goes, they floated a new tender. Defendant number 2 in the present suit
was the lowest tender.
Yes, he, my lord, selected, he was working. Now, my lord, in the present suit is that since the defendant number 2 is
1 or 2,
my lord, they both of them.
So for both.
Now, let since the defendant number
sister concern.
Sister concern. That is the case made out in the play. So is the sister concern? So whatever loss and damage alleged to have suffered for issuing the second tender, that is the subject matter of the suit in the instant case. In respect of the first
claiming damages from you.
Yes, in respect of the first NIT, my lord, there is already a suit instituted by my client, being a plaintiff, in the year 2023. Now, my lord, kindly takes up 2 or 3 paragraphs, my lord, may I place before your lordship? Kindly takes up, my lord, paragraph 19 at page 323. Has your lordship?
Paragraph
19.
Yes.
The newly awarded rate was rupees such and such ton, metric ton. Hence, for execution of the balance quantity, the plaintiff incurred and expenses about such and such. This is the new rate quoted by virtue of a new tender. So, according to them, they have quantified paragraph 20 as one of the contractor in case, that is the defendant number 1. Right? Defendant number 2. In case is already executing the same work at the higher rate, so the defendants cannot complain of any damages or loss already suffered by them in executing the previous tender work. That is the subject matter of 2023 suit instituted by my client. The defendants have willfully and deliberately connived and colluded with each other and have deliberately refused to execute the previous work even after the ECL authorities had offered to extend the time for executing the balance work in an attempt to force the plaintiff to float another tender, and they could get the said work at an inflated new rate from which they will benefit. The old rate was fixed of such and such. I am not troubling your lordship. Thereafter, they have quantified this. Kindly now takes up paragraph 25. I know, my learned senior friend will heavily rely upon this paragraph 25. The suit contemplates urgent interim reliefs. Has your lordship got it, Lord?
Yes, yes.
The defendants have already filed a suit against the plaintiff with respect to the same tender and, pausing here for a moment, not in respect to the same tender. And the same is pending before the learned court and is numbered as title suit number. This has renumbered, initially it is of 2023. In respect of the said suit, the parties have explored their possibility to pre-suit mediation. But the same did not fructify in any settlement. A copy of failure report is annexed such and such. Moreover, the defendant's joint venture is a special purpose vehicle and the plaintiff reasonably believes that unless there are appropriate order of attachment, kindly marks this portion, and injunction without requiring the plaintiff to serve notice upon the defendants, there is every likelihood that the reliefs contemplated and the paid in the instant suit may become infructuous. The plaintiff has been advised to take necessary steps in accordance with law. the parties in the instant suit are already before this learned court, and the plaintiff reasonably believes that the reference to the of the dispute and differences between the parties herein to pre-institution mediation and settlement would tantamount an empty formality, and the sake of abundant caution, the plaintiff shall file necessary application under section 12 capital A of the Commercial Courts Act 2015, seeking dispensation of the rigors of the pre-institution mediation and settlement. Though, my lord, I will show before your lordship, the Honorable Supreme Court is saying there is no necessity for filing any separate application. The law does not contemplate that the plaintiff has to file an application for seeking leave. The law contemplates that if on a reading of the plaint, the court founds the plaint contains an urgent relief, or rather not the connotation my learned senior friend can use, the suit. It is, my lord, the language of the statute. If the suit contains an urgent relief, what is suit? What is the meaning of suit? My lord, I shall show before your lordship that also. Now kindly takes up with this pleading content in the plaint. What is, my lord, the cause of action? Paragraph 30. I have shown that cause of action according to them 2023 any future date. Even that can be done, my lord. It's a bundle of cause of action, but that has not been pleaded.
Continuing. It's continuing.
My lord, subject to correction.
Subsisting till date.
Yes.
Still subsisting till date.
Yes.
So it's a continuous cause of action.
Starting from 2023. What prayer that has been made out, my lord, in the plaint? A decree for rupees such and such, including interest, pleaded in paragraph 20, interest upon the judgment such and such, till realization, a decree for costs of the institution and such further reliefs. So, my lord, this, my lord, I could have understood that a situation, my lord, the Supreme Court, or rather this Honorable Court, have carved out an exception that today you are contemplating something that yes, the situation may not arise at the time of filing of the suit, but there may be an urgent relief in future. So, the plaintiff on the day of presentation of plaint, contemplating that there is urgent relief that may have appear in future. If that contemplation is there, the court can even grant leave. But we have to keep in our mind, in the present case, my lord, the application for injunction was filed on the same day. So, it's not that the contemplation is there in the plaint, the urgency arises sometime in future, say for example 3 months thereafter presentation of plaint. It's not a case of that. So pleading made that yes, attachment is required, consciously no prayer has been made out in the plaint. So if this is a situation, and my lord, this Honorable Court also saying that yes, you have a urgent relief, but the court may not qualify your urgent relief to of such a nature that you are not being protected by an interim order. That is also not a situation where the leave cannot be granted, because it's an urgent relief appended to the suit, and ultimately the court may not allow you to give that urgent relief. That does not disentitle you to come out with the regards of 12A. That is one of the possibilities. If this is surprise, this is the contemplation of the suit itself. Keeping in this on your lordship's mind, kindly now takes up. 10 মিনিট কোথায় থাকে? 10 মিনিট তো বলবো, 15 মিনিট অন্তত, 15 থেকে 20 মিনিট বলবো একদম শিওর। তোমাকে তুমি খালি তোমার
Yes, Mr. Mukherjee.
Yes, I'm sorry. Distinguish, I'm relying.
First,
the judgment I want to cite.
No,
Patil automation, that has been, I have relied
Mr. Mukherjee, you have relied upon 2 decisions. You have relied upon the decisions
before the trial court.
No, here.
Here, my lord, I have relied upon 2025 Supreme Court.
Yes.
Here, my lord, automation is quoted.
Yes, so these are the 2. You want to cite any other decisions? On what point?
My lord, Patil automation, I have not cited before your lordship. Lord, may I cite that? Because that is important. Because this aspect has been dealt with. What is contemplation of urgent relief? That has been dealt with in Patil.
Which paragraph of Patil automation I will be relying upon? I think that has been quoted here. So for what proposition you are citing? What proposition?
Whether the suit plaint itself has to contain that. Because my learned friends content, yes, that's why not I.
Yes.
Yes. পাটিল রিলাই করে দাও কপি আছে পাটিলের কপি তুই জানিস নি
I just show it for your lordship. I'm sorry, my lord. This lord, night, my lord, I have they have made a printout, my lord, but I have this.
নিয়ে আয় I'm bringing a printout.
Lord, may I take your lordship? Lord, some of the paragraphs are important because my case is on this aspect. Lord, kindly takes up paragraph 2 once. This is reported in Lord 2022, volume 10, HCC, page 1. Here, my lord, there are classes of cases that has been dealt with by the Honorable Supreme Court. Wherein paragraph, my lord, paragraph 2, my lord, I will not place my lord, paragraph 2 and 5, 6, 7 for the purpose of only facts. What happened? My lord, suit instituted after 2018 rules came into force. 2018, my lord, amendment, sorry, and the rules came into force. The suit was being instituted without, my lord, the prior pre-institution mediation. The application was filed under Order 7, Rule 11. The learned trial judge, commercial court, ultimately held this will be arrested, parties will be relegated to, my lord, given a pre-institution mediation.
Distinction. If suits filed prior to that cutoff date of August 20th of August 2022, it will be suspended, directing the parties to approach the
and if after that 7-11.
Even before particular automation, if any of the high courts have declared that, then also you have to follow. That's the.
Here is a case, my lord, where the learned trial court arrested the suit, relegated the parties. Thereafter, the High Court was prior to this. High Court also done that, and thereafter the Honorable Supreme Court
clarified that in those conclusions.
Yes. So only for the narration of facts, my lord. Now, on this aspect, if your lordship takes up now.
Which paragraph you want to?
Yes, yes. প্রথম প্যারাগ্রাফটা কত রে? But kindly takes up now paragraph 74. Has it? Oh, no.
74.
Yes. Has it?
Yes.
74. It is noteworthy that Section 12 capital A provides for a bypass and fast track route without for a moment taking the previous time of a court. At this juncture, it must be immediately noticed that the lawgiver has in Section 12A provided for pre-institution mediation only in suits which do not
contemplate. What is the next paragraph you are relying upon?
Paragraph 83.
Yes.
Paragraph 85 thereafter, the vis-a-vis provision of section 80
was considered.
Yes, 12A.
Yes.
Now, if your lordship takes up paragraph 98.
So it's on waiver. It will not be a waiver.
It will not be a waiver. Thereafter, paragraph 98, my lord. '98 is for presentation. It will be no presentation at all.
Yes. There is a summarization.
Now, my lord, may I place, my lord, I will also rely upon 9.3 because Milord, may I take your lordship once, Milord?
Shall.
Yes. The language used under section 12, where may I read, Milord, two of the paragraphs at least,
Yes.
99.3 and 100. The language used in 12A, which includes the word shall, certainly goes to a long way to assist the court to hold that the provision is mandatory. The entire procedure for carrying out the mediation has been spelled out in the rules. The parties are free to engage counsel during mediation. The expenses, so far as the fee payable to the mediator is concerned, is limited to one-time fee, which appears to be reasonable practically, having regard to the fact that it is to be shared equally. The trained mediator can be work wonder. Now, Milord, paragraph 100 is important. In the case before us,
Only by saying that suit contemplates will not suffice.
Milord, why? It has no, Milord, it has connotation. The Supreme Court explained it has to be in the plaint. May I please that
that
portion?
is why. Even by saying
will not do.
Will not do.
Yes.
If the plaint discloses urgent
plaint, the Supreme Court has made it clear. The connotation of suit is, Milord, comparable to the plaint. Why, Milord? In the present case before the suit do not contemplate urgent relief. As to what should happen in a suit which do not contemplate urgent relief, and rather the meaning of the word contemplate or urgent interim relief, we need to dwell upon it. The other aspect relied upon by the word contemplate is that there can be attempt to bypass the statutory mediation under section 12A by contending that the plaintiff is contemplating urgent interim relief, which in reality it is found to be without any basis. The section 82 CPC permits the suit to be filed where urgent interim relief is sought by seeking the leave of the court. The proviso to section 82 contemplates
it's
that
the duty of the court to see whether there is urgent.
That's why. So, Milord, I will distinguish, Milord, this honorable court some of the judgment. If after hearing of the parties is satisfied that no urgent and immediate interim relief needs to be granted in the suit, return the plaint for presentation of the court after compliance. Our attention is drawn to the fact that the 12A does not contemplate such a procedure. This is a matter which may engage attention to the lawmaker. Again, we reiterate that there are not issues which arises for our consideration in the fact of the case. Admittedly, my Lord, kindly mark this portion. There is no urgent interim relief contemplated in the plaints in question. So the Honorable Supreme Court has not left aside, gone into the aspect. Suit, connotation of suit is there in the statute. The Honorable Supreme Court said, no, it is your plaint which has to be contemplate urgent relief. And thereafter, the court will qualify whether your urgent relief is of such a nature that the 12A leave can be granted.
Merely by saying that it
merely by saying will not do.
Making one line amendment.
That will not do, but the plaint has to disclose this. Milord, here, Milord, the urgent relief has to, Milord, there take place in the prayer of the plaint. Milord, it is a case before your lordship where there is no urgent relief prayed. So my learned friend's contention will be, it is my suit, may not be the plaint.
Any other paragraph you want to say?
Milord, paragraph 108 is, sorry, Milord, 104 is of the view that the Order 7 Rule 11 in that case will be attractive.
Non-compliance 10, Order 7 Rule 11. Yes.
Now, Milord,
please give me a photocopy of this.
Milord, I shall. Milord, my copy is there, it's marked some portion, tick mark, that's why, Milord, I will hand over, Milord, in course of the.
You have marked the portions which are against you, Mr. Mukherjee. That will help me.
According to me, Milord, nothing is against me in this judgment, at least. My learned senior friend will certainly, Milord.
Yes.
What now, Milord? Next, Jamini Monohar, if your lordship takes up, that is 2000, Milord, may I just.
Eta দিয়ে
Milord, pen to make a spiral binding, Milord, I have not, but I'm sorry. Kindly takes up now 2024 volume 5 SCC. Page 1815. Oh, Milord, page 18, my learned friend says, page 18 of the compilation. Thank you.
This is for what proposition?
Milord, Jamini Monohar is a judgment, Milord, where the Honorable Supreme Court have made it clear it cannot be bypassed also. Milord, I will place only paragraph 8, 9, 10, 11 and 12.
Yes.
Our attention,
I think Patil Automation has made it clear also.
yes, it is a
There's also
judgment,
been-
Milord, explaining Patil Automation. That's why.
Yes.
Our attention has been drawn, Milord, a Bombay High Court judgment is being cited, Milord, at paragraph 8. In my considered view, it is a quotation of that judgment, Milord. A paragraph 8, Milord, quotation from the Bombay High Court. In my considered view, the proper course would be to assess whether there are elements which prima facie indicate that the suit may contemplate an urgent interim relief, irrespective of the fact as to whether the plaintiff eventually succeeds in getting the interim relief. It is a worst case scenario where an application for interim relief is presented without being any justification whatsoever for the same. To simply overcome to a bar under section 12A, the court may be justified in recording a finding that the suit in effect does not contemplate any urgent relief, and then institution of suit would be a technical in the teeth of section 12A of notwithstanding a formal application. Now, Milord, kindly takes up paragraph 9. Paragraph 9, Milord.
9, subparagraph 35.
3.2. Milord.
Subparagraph 35.
32, Milord. 32, may I please, Milord?
Yes.
Second, a suit which does not contemplate urgent relief. Here, Milord, is a case. Cannot be instituted without exhaustion of the pre-institution mediation as required under 12 capital A1 of the Commercial Courts Act. As noted above, the Supreme Court has held that the said provision is mandatory and is compulsory for a plaintiff to exhaust the remedy of pre-institution mediation in accordance with the rules before institution of the suit. The court has no discretion to exempt the plaintiff from the applicability of section 12A of the Commercial Courts Act. It is not permissible for the court to pass in an order contrary to law. Therefore, an application seeking exemption from engaging the pre-institution mediation in a suit that does not involve an urgent interim relief would not lie. Now, Lord kindly takes up 34, where your lordship is on. The use word contemplate any urgent interim relief as used in section 12(1) of the Commercial Courts Act of 2015 are used to qualify the category of a suit. This is determined solely on the frame of a plaint and the relief sought. The plaintiff is the sole determinant of the pleadings in the suit and the relief sought. So, my lord, it is no more res integra that I am showing before your lordship. My learned friend can join an issue. No, my suit. No, suit has to contemplate in respect to your pleading made in the plaint.
Yes.
Now, my lord, paragraph 35. The court is of the view that the question whether a suit involves an urgent interim relief is to be determined solely on the basis of the pleadings and relief sought by the plaintiff. If the plaintiff seeks any urgent interim relief, the suit cannot be dismissed on the ground that the plaintiff has not exhausted the pre-institution remedy of the mediation. Now, my lord, kindly turns over the page. Paragraph 10 and 11 is very important because, my lord, here also Honorable Supreme Court made you cannot bypass. We are of the opinion that
when distinction between interim relief and interim relief that has been made in paragraph 10.
And paragraph 12 also I will place, Milord, it has been again suggested it has to be in your plaint.
Yes.
Paragraph 10, Milord, may I place, where we are of the opinion that when a plaint is filed under Commercial Courts Act with a prayer for an urgent interim relief, so it's plaint, the commercial court should examine the nature and the subject matter of the suit.
This is the duty of the court.
Yes. The cause of action. The prayer for interim relief. So it has to be connoting the plaint. So starting language was prayer made in the plaint. The prayer for urgent interim relief should not be a disguise or mask to wriggle out and to get over section 12A of the Commercial Courts Act. The facts and circumstances of the case have to be considered holistically from the standpoint of the plaintiff. No grant of interim relief at the ad interim stage when the plaint is taken up for registration, admission, or examination will not justify dismissal of commercial suit under 711 of the code.
So this is the distinction between ad interim injunction and 12.
Yes, I say that, Lord. My opening sentence was that you may pray, you may not God. Dismissing order 711 because the interim relief post the argument is denied on merits and the examination of the three principles, namely such and such. Paragraph 11. Having stated so, it is difficult to agree with the proposition that the plaintiff has an absolute choice and right to paralyze section 12A of the Commercial Courts Act by making a prayer for urgent interim relief. Here it is a case where nothing has been made. Camouflage and guise to bypass the statutory mandate of pre-litigation mediation should be checked when deception and the falsify is apparent and established. The proposition that the commercial court do not have a role, albeit a limited one, should be accepted. Otherwise, it would be up to the plaintiffs alone to decide whether the resort and the procedure of 12A of the Commercial Code Act, an absolute and unfettered right approach, is not justified if the pre-institution mediation under section 12A of the Commercial Codes Act is mandatory as held in such and such. Now, paragraph 12 below. The word
Contemplate has been explained from the plain
Yes.
documents itself. Yes, what is the next decision?
Dear Milord, 2023 SCC online, দাদা এটা একটু বলবে? ক্যালকাটা এটা কি সৃষ্টি না সৃষ্টিটা আগে দেখাবো? সৃষ্টিটা লাস্টে দেখা।
Calcutta page
Page 2443.
for what proposition?
Milord, here kindly takes up once paragraph Milord,
It is here.
Milord, it's the compilation. 2023 SCC online, Calcutta, page 2443. It's Gavril Metal Private Limited.
Yes, yes.
Paragraph 11, Milord, may I please?
For what proposition?
Milord, here, Milord, certain lighter view is being taken. According to me, Milord, I should, Milord, place all these, Milord, because your Lordship will decide ultimately. Milord, paragraph 11, has your Lordship got it, Milord?
Yes.
The legislature does not say the relief should be urgently sought for from the court, or the time period within which the relief is to be sought, or the nature of the relief to be sought to qualify of an urgent relief. The legislature only mentioned that the suit should contemplate urgent interim relief. So some, Milord, relaxation are tried to be given. Milord, kindly now takes up paragraph 17. So the test, as you Lordship, so the test, in my opinion, is not whether an urgent interim relief is immediately required, but whether the averment in the plain point of a situation where even before expiry of 3 months, the plaintiff may have the need to obtain the interim relief. Milord, in my respectful submission, this is exactly contrary to the proposition laid down in Patil Automobile. It's not about your intention or your subsequent innovation that something will arise, may arise. There is no proposition, Milord, laid down to that effect. In that case also, if your Lordship takes up, some portion of the paragraph is being quoted, Milord, in paragraph 19. These were the situation, paragraph 21 now. On a reading of the plaint, particularly those two paragraphs inserted above, there is
I've
no
seen
doubt.
that.
Yes.
Very weak. The court holds indeed
very
very weak.
And thereafter, the court said, but since there is some element of fact pleaded in the plaint, so this can be done. But this judgment will also not very clear whether any interim relief is prayed in the plaint itself or not. But I must show before your Lordship, this ratio of the decision will be contrary to the ratio of the decision laid down by the Honorable Supreme Court in 2022, 2024, and last decision of the 2025 also. So according to me, this cannot be a binding precedent before your Lordship.
Yes.
Now, my Lord, kindly takes up.
So these are the judgments which Mr. Ghosh will rely upon. Let him cite first.
I must, my Lord, point out the distinction that I have already found.
Let him cite. He may not cite some of the decisions.
Lord, he said, Lord, he handed over me this list because he said, Lord, he will going to cite. That's why, Lord, to cut short the time. Since Mr. Ghosh is not here, Lord, certainly, Lord, Mr. Ghosh.
That's the arrangement made between both of you.
Certainly, Mr. Ghosh will, Lord, cite according to his own way.
Yes.
Lord, but what distinction I have already found. Lord, kindly now takes up, Lord, 2024 SCC Online, Calcutta, page 7817.
2024.
2024 SCC Online, Calcutta.
Yes.
Page 7817. This is Srishti, my Lord. reply বলবো। Kindly takes up paragraph 30.
You have not brought the judgment delivered by Justice Tandon.
Yes.
These are the compilations you have made. Both of you have done research work.
In my respectful submission, if today a binding
got that?
precedent
Is it in the
of the
compilation?
Supreme Court is there. Will
it in the compilation?
Your Lordship, with regard to the other views, other views of the different High Court has been considered, and ultimately the Honorable Supreme Court has made the framework. If that be the situation, we should not trouble your Lordship with regard to this aspect. But still, since my learned senior friend has given me the copies of the citation he wants to rely, may I point out to your Lordship paragraph 32 of this judgment.
Which judgment?
Srishti, 2024.
Yes, paragraph
32.
Yes.
Why I say this is no more res integra. But please note that the wording 12 capital A1, the legislature does not mention
better to refer it.
There is no Supreme Court judgment, then I ought to have been being an officer of the court, should ask before your Lordship, pray before your Lordship for the reference.
You have not brought any other division bench in your support.
Today, if the Supreme Court is there,
but these decisions, the Supreme Court was considered.
But that line, that paragraph where it has been placed that it is the plaint which contemplates the relief, that was not considered. Referring a decision and considering it in that angle is something I could have understood that the Honorable Supreme Court has said plaint, but I am saying no, it will include the interlocutory application. Could have been said in that way, that distinction subject to correction is not here. Kindly see paragraph 32. Please note that the wording 12 capital A, the legislature does not mention plaint. It used the word suit. It employs the word contemplation. Hence, it avoids such word, the averments or statement in the plaint. In other words, the legislature does not say that from the statement or averment in the plaint, urgent reliefs that from the statements and urgent relief obtained by the plaintiff should be apparent. It would interpret the section as suggesting that, in fact, the time of presentation of the plaint before the judge from the averment in the plaint and the affidavit to be filed by the plaintiff, it would appear that the contemplation of the plaintiff in a situation of urgent relief might arise in a period when the mediation has been undergone. The court may allow the plaintiff to institute the suit without mediation. I am not in issue with regard to the second proposition of the Honorable Division Bench, because second proposition is absolutely right. You may ask, you may not get. But the contemplation of suit and plaint that has been made and clarified by the Honorable Supreme Court, this point is no more a res integra.
Yes.
But regarding the second issue, I am not joined. Now, the last decision is there 2025 SCC online Calcutta that I want to rely, page 2426.
That's the latest judgment. 2025 SCC online
Calcutta, page 2426.
2426.
This is Calcutta, paragraph 10. 10 and 11. Here, Mr. Ghosh appeared, for the defendant. Paragraph 10, has your Lordship got, from the compilation? In view of the above, there is a limited scope for the court to examine the grounds for revocation and of dispensation with the requirement of pre-institution, mediation and settlement. Section 12A, I am not troubling. This again, reiterates, that how, this has came, the rules and all that. Kindly takes up paragraph 11. There can be no straitjacket formula in such cases. Ravi Kapoor. Each case depends on its fact. It is true that the section does not provide for any exemption to any particular class or category.
Here it was held that the suit also do not contemplate urgent
plaint.
Yes. Anything more?
And in the Justice Tandon's judgment is 2022 SCC online, Calcutta, page 3951. I I rely upon para 25, 27 and 28 of this judgment.
You have not brought that.
It is in the compilation.
Yes.
We both of us not argued before the trial court. That's when
which
serial serial number ta bolon. Serial number 5.
5, 39 to 56.
और judgment ko shuru the paragraph 25, 27 and 28.
No, not this judgment.
Oh.
There's another judgment. Yes. You are relying on
Paragraph 25, 27 and 28.
paragraph 25,
27 and 28.
Yes. Anything more?
No, not only one thing. There are classes of cases prior to the Supreme Court judgments that this can be said to be an empty formality. What my learned friend has.
No, but all these judgments which are in the compilation are post this Patil automation.
Patil automation. But Patil automation has been followed by the Honorable Supreme Court in 2024. That the judgment I have cited before your lordship.
Yes.
That is 2024 is of ওটা কোনটা ছিল রে 2024 এর যেটা কি নামটা ছিল মনোহর
2024 5 SCC
Jamini Manohar holds the field said that that is the correct law laid down. 2025 judgment which I have cited before your lordship that also holds that yes.
Where is that citation of 2025?
2025 milord.
This is Partiwala's judgment.
Yes. 2025 SCC online Supreme Court page 1129. This milord
1129. Yes, you have given that. Yes.
So if this is the law laid down, milord, whatever the decision that may have arisen by this time, by the different high court, in my respective submission is not of any matter before your lordship.
Yes.
Binding precedent. And milord, my learned friends, milord, contention in the milord prayers, in the averment made in the plate that what in respect of a separate tender, the parties may have instituted, because there I am the plaintiff. I not resorted for pre-institution mediation. That failed. That does not mean that you will not. It will be an empty formality. After 2022
that is
judgment,
to a different tender.
And that too, milord, after 2022 judgment, milord, this will not be an excuse at all.
That suit was prior to that.
No, that suit is of 2023. So after 2022 judgment.
After 2022.
So it was mandatory. I availed of that. I being a plaintiff over there, I availed of that.
But their argument is that since it failed, no useful purpose
that
will be
window will not be there after 2022 judgment.
Yes.
According to.
Yes.
Before that, they file a suit, there was two tender, First tender, both the petitioner, was party, There, there was a contract given to them, for breaking of coal, Now, in that contract.
Not on facts with regard to this. Don't go to those facts. I'm on a legal issue.
One thing I missed out, on the day of presentation of plaint, application for injunction filed, till date not being moved. Till date. It is not a case that injunction application is being moved and no interim relief.
On the date of filing of the suit.
The first date injunction was moved.
Injunction application filed. But not moved.
From the order sheet, it will be apparent.
But
page 426.
Urgent relief not moved.
Not moved in a separate interlocutory application, not appended to the plaint.
Yes.
Kindly comes to the order sheet, First, my lord, it was moved, my lord, but my lord, the court did not granted us for injunction, my lord, asked my lord, did my lord, and asked us to serve a copy, my lord. If your lordship seeks, my lord, first page, my lord, kindly see, my lord. Page 426, my lord, order sheet, my lord, order number 1. Considering the submission, since the suit is accompanied with an urgent relief of under 20 days, and kindly see, my lord, the plaintiff paid an account the court fees, my lord, the plaintiff has produced a physical copy.
Yes, yes, you need not place the entire, I have seen that. Yes.
Kindly
Summons of the suit.
Someone of the suit, my lord, and my lord, that day, my lord, the application was also moved, my lord. Can you see learned advocate filed order 29.1 and 2 of the CPC and temporary injunction and identity injunction along annexure and registered and such dated. The plaintiff has also filed an application praying for service of upon the defendant to registered post with AD, and it was not reflected in that way, my lord, but it was moved, my lord. And we were asked, my lord, but
yes,
my lord.
Yes, Mr. Ghosh. Start.
আমি কিছু কোনোদিন বলেছি অত বড় মামলা জিতে চাই Lord, kindly, for me, Lord, kindly look
Very dangerous to rely upon the other side. You don't know when he will stop.
Lord, we may shout, fight, Lord, but if I request him something, he will, Lord, continue. Because nowadays, Lord, there's a lot of pressure on the benches. They have to deliver judgments in time. And they have to hear matters.
Yes, yes, Mr. Ghosh, please start. Yes.
That is the difficult.
Yes.
Now, if a lordship straight away comes to the impugned order.
Yes.
The impugned order, if your lordship finds is annexed at, it's part of rather, not annexed, the last volume 3. I just place it with some cryptic manner, then lordship decides what he has decides. Millard, if your lordship takes Millard, I read Millard, my learned friend's argument. Para 3, if your lordship takes the first page, it's a money suit with a claim for interim relief and Millard attachment for judgment. Now, Millard, normally in a plaint, Millard, in a money suit in Millard district, though we played attachment on either normally here Millard on Alipur, attachments are there by way of an interim relief. Millard, kindly take Millard, serial number 3 or paragraph number 3. The plaintiff also filed an application seeking exemption from compliance with 12A of the Commercial Codes Act 2015. Leave was granted to the plaintiff on 21/1/2025, considering the urgency in the matter. So, Millard, that time, position was not settled by Dhanbad Fuels. So, Millard, adequate precaution, I gave a detailed urgency application, which Millard, the Honorable Judge Millard, felt Millard in his wisdom that should be, but he made it clear that if ex parte I will not pass, you please serve and come. We always do that, Millard. Lordships, I am sitting here, Lordship also do. Now, Lordship takes Millard, the Advocate General's argument is at paragraph 4. Mr. Such
those are the arguments.
Yes.
Decision cited. Now show me the finding.
Yes. Decision
What's the
cited.
finding?
Now, Millard, kindly, if you Lordship takes my argument, I will be rather, Millard, the time will be short. What was my argument? That's it.
Yes.
Millard kindly makes Millard the Advocate General's argument. Millard kindly take, there was no real urgency for the plaintiffs to seek exemption under 12A to file the suit without resorting to pre-institution mediation. He also submitted the fact that plaintiff did not press any interim relief on 21st January 2025 and would demonstrate the suit does not contemplate urgent relief. This is not the test, perhaps. He also submitted the cause of action as arising to the plaintiff on 29 January 2023. Therefore, there was no urgency for exemption for a pre-suit mediation. The learned senior advocate also submitted Section 12A of the Commercial Code Act is mandatory, and mere filing an application would not exempt the plaintiff of compliance under 12A of the Act. Millard, he refers to Jamini Mono. Now, Millard, I pause here for a second. Jamini Monohar Lordship will see the suit was not ultimately dismissed. There are only discussions. So far as Dhanbad Fuels is concerned, it was a case pre-party. So, Millard, the Supreme Court says, Millard, exactly quotation, that Millard, if it's a pre-party situation, then the suit should not be dismissed but Millard, it will be kept in the abeyance. But for post-party situation, the suit has to be dismissed if the plaint does not contemplate urgent relief, and contemplation is on the plaintiff, not on the defendant. Suit. Contemplation is on the plaintiff.
No dispute
not
on
the
that.
defendant. No dispute on that. Now, Millard, what is the limited window of Jamini Bona? Because it's nature of Order 7, Rule 11. You have to, Millard, proceed on the basis of the plaint. The limited window of Jamini Monohar, paragraph 10 says, Millard, of Jamini Monohar, that Millard, falsity and deception, Millard, which is apparent from reading of it. So, Millard, if there is a cause of action, I have to cause of action and explain it. What is the limited window? The limited window is, Millard, falsity and deception. Nothing more, nothing less. And contemplation on the plaintiff, what the plaintiff has to do. Because, Millard, before Millard, Jamini, there was Patil, then Dhanbad Fuels. So Patil was the case where there were 6 suits, money suit, where admittedly 12A leave was not obtained. Para 92, 93, 94. Admittedly not obtained. Admittedly no Order 39, Rule 1 and 2 was filed. So, Millard, in that context, Supreme Court says that, Millard, we are dismissing the suit and it's a suo motu power given to the court. But we are not deciding the issue as to what would happen if the suit contemplates an urgent relief and an application for injunction has been filed. So, Millard, Patil is not a ratio for the purpose where, Millard, a suit, Millard, where the plaintiff contemplated an urgent relief and an injunction has been filed. That's, Millard, clarified by, Millard, our division bench, Millard, in Srishti. Clarified. There is one more of that division bench. I also, Millard, says so. Now, Millard, kindly take, Millard, para 5, my argument. Per quantum, Mr. Such and such for the plaintiff submitted, Millard, we did it on the virtual mode, Millard. Not we are going there. Have already filed a suit against.
No difficulty even if you went there physically.
Millard, going there, Millard, the drive is good.
Yes.
With the same tender and is pending before this court, he submitted that in the suit, parties has explored the pre-suit mediation without any result. So this is the first suit, suit A. Now, Millard, he also submitted in paragraph 25 of the claim, the plaintiff specifically pleaded that unless there are appropriate orders of attachment and injunction without requiring the plaintiff to service notice upon defendant, there is every likelihood that the relief spread in the suit may be infructuous. He also submitted that since the parties are already before the court in another suit by the defendants, any reference to the disputes and differences between the parties to pre-institution mediation settlement would be an empty formality because the parties are already fighting. Now, Millard, there is a GV. In respect of A tender, which is A suit, Millard, the work site is the same. The employer is the same. The contractor is, in respect of, say, Millard, in respect of contract 1 is A and B. In respect of contract 2 that is terminated, in respect of contract 2, employer same, site same, it's B who is there, a part of constituent of the consortium. Now, Millard, the learned also relied upon the decision of Jamini Monohar has submitted the plaint, have not suppressed that the cause of action in the instance arose on about 29/1/2023. He's also some defendants have failed to show any deception or falsity of the plaint. He submitted suit contemplates urgent relief, Order 39, Rule 1 and 2, and these judgments are quoted. I'll not place them in entirety. Today we have a Dhanbad Fuels. Now, kindly take, Millard, para 7, where 12A is quoted.
You need not place that because it's a quotation of section 12.
Kindly take the observation or the finding of the Honorable Millard, learned Millard, commercial court judge. Kindly have a look at paragraph 8.
Paragraph
8, page 5.
Yes.
Therefore, subsection 1 of 12A mandates a suit which does not contemplate urgent relief under the Commercial Court Act shall not be instituted unless the plaintiff exhausts the remedy of a pre-suit mediation. I stop here for a moment. Millard, if I file a suit in commercial division, these are the cases of what? Party. Filing of a suit in commercial division without any application, seeking dispensation of the rigors of 12. Because filing of a suit is one's right under the Constitution or the legal right under section 9 of the Code of Civil Procedure. That is, Millard, I said deferred, my lord, by the Commercial Courts Act for the mediation period, that without any urgency contemplated, you cannot file a suit. So your right to file a suit is not taken away, but deferred. That's the test. And the case is what? You have to ask for dispensation. Without dispensation, you cannot ask. Without leave, we ask. There is no concept of leave, like 80 subsection 2 of the Code of Civil Procedure. There is no concept of revocation, like 80 subsection. So if you don't revoke, do that process and come back after 3 months. It's also not. These are all done by judicial pronouncement. So leave we talk, it's a question of dispensation. So much lesser test according to me, understanding of the subject. Now, a court may, however, grant an exemption, because this was my argument in the court. Under 12A of the Commercial Court Act, when the suit incontrovertibly contemplates urgent relief. In the other words, plaintiff can demonstrate that immediate relief is necessary. Such adherence to mandatory instituted mediation procedure would frustrate the very purpose of the suit. The court is empowered to dispense with mediation. The exception is designed to ensure litigants' right to urgent protection is not unduly curtailed by the procedural requirements. Now, Patil is quoted. I'll quote from Patil, Miller. Kindly omit that, Miller. Now, Miller, what is the view of the Honorable Single Judge in respect of Patil? Paragraph 10, page 6. The judgment of Patil Automation Supra was once again considered by the Apex Court in Jamini Manohar, where the Honorable Apex Court held, whenever a plaint is filed under the Commercial Courts Act with a prayer for urgent relief, the Commercial Court should examine the nature and subject matter of the suit, cause of action, and the prayer for intent, whether there is a prayer or not. Now, Miller kindly takes. The Apex Court further held that prayer of urge should not be a disguise to mask or wiggle out of Section 12 of the Commercial Courts Act. The facts and circumstances have to be considered holistically from the standpoint of the plaintiff. So, Millard, nothing new. Millard, whether the plaintiff discloses the cause of action, Millard, in its plaint is from the plaintiff and not from the defense of the defendant. Now, Millard, kindly take para 10. We are of the opinion that when the plaint is filed under the Commercial Courts Act with a prayer for urgent interim relief, the Commercial Court should examine the nature, subject matter of the suit, cause of action, and the prayer for interim relief. The urgent prayer should not be a disguise to mask or wiggle out 12A of the Commercial Courts Act. Facts and circumstances. This is an addition.
Yes.
Facts and circumstances of case have to be considered holistically from the standpoint of the plaintiff. We read the first 4 lines, but these are connected with the next sentence, holistically from the standpoint of the plaintiff. Non-grant of an ad interim relief at an interim stage, that is fixed for final hearing. When the plaint is taken up for registration and examination will not justify dismissal under Order 7, Rule 11 of the court. Because it has been argued that he has moved it. Till now, Millard, its no injunction has been granted. At times, interim relief is granted after issuance of notice. Notice issue is already there. Nor the suit can be dismissed under Order 7, Rule 11 because interim relief post argument is denied on merit on examination of the
Yes, these paragraphs were placed by Mr. Mukherjee, 10, 11, and 12.
Now, Millard, 10, 11. Now, 11
and 12.
Millard, if your lordship takes Millard. Having stated so, it is difficult to agree with the proposition that the plaintiff has the absolute choice and the right to paralyze 12A of the Commercial Court Act by making up there for interim relief. Camouflage and guise to bypass the statutory mandate should be checked when deception and falsity is apparent or established. This is the limited window of Jamini Manohar. Suppose, Millard, I have a cause of action in 2016. I don't plead and explain. I say I came to knowledge on 2024. That is falsity and deception. If I open my all cards before the court, Millard, and say, please give me 12A, leave, where is the question of, Millard? Falsity and deception. Apparent from the plaint. I have not said so. If this is the limited window of Jamini Manohar.
Mr. Ghosh, what is the purpose of introduction of 12A?
Yes. The purpose of introduction is 12A is, Millard. I answer, Millard. Is, Millard, look, you go and settle with a party so that if there is even a rarest possible chance, either there is a settlement, which is like a decree of court when you come back on court, or, Millard, there is, Millard, no settlement, failure report, I come back. This is all.
What is section 80 subsection 2 of CPC? What's the object?
Kindly take the object of, Millard, CPC. CPC টা দেন। ওই তো আছে, ওটা দাও না। আমার বইগুলো আনতে বলো এবার। Thank you. Kindly takes me Lord, section 80, subsection. Lordship. Are sued to obtain urgent or immediate relief against the government officer in respect of an act purporting to be done.
Yes, yes.
Thing to done by the public officer in official capacity may be instituted with leave of court without serving any notice as required under subsection 1. So, my lord, without notice, I can do it.
Why? What is the purpose for this?
Purpose.
And what are the things we have to say in that? You see, in the name, description, residence, reliefs claim. What's the object behind this section 80?
If there is no urgency, government should get a notice.
The object is in other way, to avoid filing of suits. That's the prime object of 12A as well as section 80. Don't burden the courts. You have a relief, claiming a relief against some authorities. Please serve a notice. Yes, they can solve it. You need not approach the court. Same is the object of section 12A.
Subject to correction, Miller. Whatever. Subject to correction, this is clarified, Miller, in party automation, Miller. Perhaps, Miller, there is a difference between it.
No. Mr. Ghosh, I'm not saying that is, but the ultimate object.
Yes.
If you read section 80.
Ultimate object of the legislature is don't burden the court, go to tribunal and go to mediation.
Yes. So that's the ultimate object. So that's the ultimate object. Act is also coming, Mediation Act and other things.
If you have
so objectives,
like
if the parties can make an attempt, section 89 is also there.
Kindly
that's the
kindly take this situation. If already in respect of a site there is an ongoing
No, Mr. Ghosh, I'm not saying that all disputes can be solved, but I'm only concerned what's the object. That's the only object of.
Object is curtailment. Please don't come to court, try that out and come back.
Yes. So don't burden the courts. Attentive, it can be solved in other way.
I had the bill, Miller, why this came into effect. This is to lesser the burden of the
Yes. That's the ultimate object, nothing more.
Is much more because 80 you are suing a government. So you get settled it before the government and come back because 1908, Miller, this is conceptualized pre-Miller, the invention of
12-way dispensing is object is more or less like that injunction without serving. If it is defeated by the delay, ex parte can be passed. It's also dispensing will, if you have to go to the mediation, some time will take. So urgent reliefs you may suffer for this dispensation. That's the, if you can combine all these provisions, that's the ultimate object.
So far as our division bench is concerned or our courts, single bench are pro in dismissing the suit. Division benches, Millard, are pro Millard in retaining the suit.
So, Mr. Ghosh, that's a different thing altogether. It's not a case of that goes from facts to facts, whether it's on dismissal of the suit or from.
Yes, if Lordship takes the Srishti case. Srishti, that's the division bench. What happened, Millard? Rajarat Court, Millard, said, I cannot entertain a plaint dismissal on the first day. Appeal there from like a decree, Millard. Millard, appeal was succeeded on the ground on the contemplation ABC. And if you want mediation, in your petition, you have to say that what useful purpose the mediation will serve. Otherwise, this will be viewed by the court with suspicion. Now, this went up to the Supreme Court. SLP was not entered.
What's the meaning of that?
This went up to the Supreme Court. Now, Dhanbad fails also 66FG, Lordship will say nothing new, nothing. In the facts of the case, where the parties are already before the court or one of the parties, same subject matter, and yes, the site is same, sir. If you take it, then whether it's useful to do for the mediation or not. Because I cannot, if you are already in court and the other suit is proceeding ex parte, will I not look for mediation? Lordship has to see. This is what Vedasi says, because neither party, nor Srishti, nor Dhanbad case are the case where cross suits were made. Now, what is the effect in cross suits?
So that's the distinction according to you.
Yes.
According to you, in the suit filed by Mr. Mukherjee's client, so they went, parties went before the mediation, it failed.
If it is already
So
fixed,
no useful purpose will be served in
failure report. Whatever, it's a failure report, and the first suit is filed with a failure report. Will the second suit, my lord, I have to go, my lord, when there is a failure report? Whatever be the reasons, there is a failure report. Just one day ECL couldn't have appeared, my lord, mediation closed, suit filed. Normally 3 dates are given, but in Asansol, I don't know the procedure. It's 1 day. It's recorded in the order itself. So what useful purpose mediation will serve? And these are all cases. Party lordship will ignore altogether because 66 paragraph makes this clear. We are not considering a position where the suit contemplates an urgent relief, and what will happen, my lord, then 12A is granted, whether revocation can be granted or not. Chamini Monor suit not dismissed. And my lord, Dhanbad fuels pre-party. So how does it apply in the facts and circumstances? My lord, may I continue at 2 o'clock?
how much time it will take?
I'll take today, tomorrow, when lordship gives me, I'll cite.
How much time I ask you? How much time?
When our lordship gives me.
Half an hour. Let me see.
Any date?
4 থেকে ফাঁকা আছে। এখন fix আছে কিছু? Today. Come at 14.
Before your lordship rises.
Wait a party.
The outside, my lord, I apologize, your lordship. Unfortunately, I was unable to mention in the morning. Maybe for me to mention, my lord, for inclusion in the list, your lordship.
Please come in the next week. Yes.
I'll wait till whatever time lordship. 4 p.m. I'll come and.
Yeah. The matter was supposed to appear.
Mr. Ghosh, your junior has given this
Party has missed out.
I will hand over party. Your junior has given this compilation.
I'll not place I'll only tick the paragraphs. This will exercise I'll do in the tiffin hours so that it's quick.
Lordship, before Lordship rises, may I have Lordship.
Number 26.
Lordship, I appear on behalf of the petitioner plaintiff. Lordship, the plaintiff had instituted a suit for eviction on the ground of default in payment of rent.
Yes,
The
what is the impugned order?
Lordship, impugned order, Lordship, in this case, Lordship, the 7-1 was allowed. We are challenging on the ground that it was barred by the statutory period, which was not filed in the 1-month period, Lordship. Lordship, if I may just give you 3 dates. The suit was filed on 30th March 2022. The summons were admittedly delivered on 12th April 2022, and the 7-1 was filed on 30th June 2022. So our principal ground is that it could not have been filed because it was beyond the 1-month period, and summons had been delivered on 12th April. And Lordship, there's also an order of 13th May 2024 recording that
When the application was application was filed.
Lordship, the 7-1 application on 30th June 2022.
30th of June 2022.
Yes, Sir Lordship. Lordship, we have attached the certified copy of the orders. It begins after page 53.
So the next date was fixed on 12th of July.
Yes, Sir Lordship. It was fixed on 12th of July and they entered appearance on 30th June and they filed a 7-1. Now, Lordship, another order I'll point out, Lordship. Now, since you have attached the certified copy, it's not paginated, Lordship, but there's a 13th May 2024 order where the advocate on behalf of the defendant admit that there has been a delay on their part on the ground of ignorance of law. He had mentioned that there was a delay. Now, thereafter, they filed a 151. This order was dated 13th May 2024. He filed a 151 seeking recalling of
What
this.
is the suit filed on what ground?
Eviction on ground of default of payment of rent.
Only default.
Lordship, principal ground is default of payment of rent.
So any other ground is there?
Lordship, the plain starts at page 21. I'll be candid, Lordship, that's our principal ground.
It prima facie appears.
With respect to 7-1.
7-1 has to be stayed. Otherwise, the
Your
striking
Lordship,
out of
suit
defense. Striking out of defense is there.
7-3 would
So
have.
defense will be struck off. Suit has to be stayed. Yes.
Settled laws ought to be unsettled.
Settled laws
Ought to be unsettled by the learned judge.
That is why you are here.
Order 39(7), they ask for take evidence so that who is in possession of it.
That has been allowed. Where are the points?
Or can you see the order?
No, I've seen the order. Where are the points? Order does not say anything allowing application, elucidating the.
Page 62.
What is the suit for?
Suit for declaration and permanent injunction. In that
Declaration of title.
declaration of title, can you come to page 10 at 17? My lord can get it at page 17.
Where are the points?
Page 62 can you come? The application.
62.
Yes.
Yes, where are the points? I cannot get the schedule. Where is the schedule?
There is no schedule. Can you come to prayer? 67.
Oh, in the prayer it has. Yes, Mr. Mukherjee.
Got a badly drafted application. You got Schedule B and Schedule C. The declaration and injunction
This has been allowed.
Just Lord, I'm
So I'm setting it aside.
may I just Lord, indicate thereafter, Lord, Your Lord. Schedule B and Schedule C is the property under dispute, which I purchased. According to me, the defendant is my relative. I was at China for the business purpose. So Lord, that is the plain case.
And when you were in China?
Lord, that
Which
is also
period?
declared.
Which period? Not it.
Which period? Which period?
Not it. Provis.
Year.
Lord, yes, Lord, just Lord, at the
2019.
no.
Then
It's not 2019, Lord, it's 2023. 2023.
so it's the
Post.
third or fourth wave.
Yes. Lord, now, Lord, I required him, the relative, the defendant, for the purpose of undergoing the repair work. Schedule B is a property, Lord, is a room which used by the plaintiff, who is one of the advocate, for his own chamber. Schedule C is, Lord,
No, this is in aid of repairing.
not aid of repairing. But in such a suit, declaration and permanent injunction has been sought for that I am in possession, I running the advocate's chamber from the Schedule B property. After the court hours, everything is being mentioned. But they have denied, they said they are the premises tenant. But that will be from the documentary evidence. Your Lordship knows in a kind of suit, like the even recovery of possession on the ground of in kind of suit for recovery of possession of eviction of
Yes, any
tenants also.
difficulty in taking up? Any difficulty in taking up this matter?
One person I have to retire.
She is practitioner of bank.
Yes.
So, in a classes of suit, even the mode of user of the property can be looked into by local.
That is not.
inspections. That has not been prayed. That has not been prayed. But
it has been allowed.
My purpose will be subserved if your Lordship restrict it to only show by the learned advocate by the mode of user of that.
This application under Article
Kindly,
227.
may I the Honorable Division Bench have taken pain to exercise this effort for the purpose of showing
Not a decision.
the first page 3-4 line your Lordship kindly see the first page.
Not a decision. This is not a decision.
This application.
I restrict myself only to
Mr. Mukherjee has sought for.
Number 28.
I will remember this, Mr. Basu, when he will appear. When he will appear with a similar appearance, I will remember.
I never. It goes without saying.
Yes, yes, yes.
This is my action. Yes, for divorce. But I am the husband petition.
What is the impugned order?
Lord, here the impugned order is Lord 13th, 30th, Lord April.
30th of April.
Yes.
What has been done by 30th of April?
Kindly have a look of this. It's very interesting. Lord, your Lordship, kindly have a look of this.
30th of April or 3rd of April?
3rd April. Lordship is looking. Type copy.
3rd of April. Where is the type copy?
That copy is there. Lordship, kindly have a look of the type copy.
Yes, I've got that. Yes.
Order number 15.
Yes.
Parties fixed files are files are fixed the prosecutions of one to ensure the further prosecuting part and prosecuting clear of the document namely shows the priority for prosecution. Thereafter, again continue. Please a file copy of the order dated.
Yes, what happened?
May I say only 2 lines. Suit was filed in the year of 2022. It is said it was filed by the wife 2022. Thereafter, my lord, the husband, my lord, filed his evidence against that, my lord. They have started prosecution since 1st August 2024. 1st August 2024. Thereafter, they never, my lord, completed the prosecution. Thereafter, my lord, we came before this honorable court. This honorable court directed the landed court, my lord, to endeavor so that the entire suit can be disposed of within a period of 1 year.
Yes.
After that, when I submitted the order, copy of the order before the landed court below, then Milord, he has not passed his impugned order.
What impugned order?
Impugned order is, Lord, your Lordship, kindly have a look of the. There are 3 orders in one date.
What has been done? I cannot follow. What has been done?
Here, Milord, Lord, your Lordship, kindly have a look of the page. Lord, this one, your Lordship, kindly have a look of it. This one is the type. Your Lordship, kindly have a look of it.
Order dated? No, what has been done? Please tell me.
Here, the court below directed the parties to submit their citizenship documents. Only to delay the matter because of the view that before that we submitted the order of this honorable court. This was a matter in 1st August 2024, they have started prosecution, they never finished.
No, that is you have filed these documents. No document is filed.
Both parties were directed.
Yes.
Both parties were directed.
Where is that direction? No direction. The petitioner has filed this as per the list.
3rd June.
Yes, 3rd June the petitioner on his own filed this. You are the petitioner of the opposite party there in the suit, matrimonial suit. You are the opposite party there.
I filed the suit for divorce.
So why have you filed these documents? Why have you filed these documents? List of all genealogy. Why have you filed this?
Only to complete the entire proceeding within a short time in terms of the order.
You have complicated this. You have a full genealogy, list of clan. You have complicated this.
You have to complete the entire proceeding within this.
So 28th of July it has been fixed. What is the problem?
Thereafter, 3rd June, you also tell me that.
I am on 3rd June. 3rd June, the opposite party has been directed to file this. You are not the opposite party.
The document was also directed. Before that, on 3rd April, both the parties were directed.
Show me that. You are directed to file this clan and the. It is not there.
I am showing this one. You also come to Third appeal last, continue to order, that is this portion.
Oh, yes, yes.
Your logically, I'm just going. Upon going to the cross-examination of PW1, which is for the date, it appears to me that father of the prisoner and mother of the respondent were friends with their dates as so and so and so. The prisoner being cross-examined and also been dated so and so and so. It goes without saying that the data is Bangladesh people are not Indian citizens. These parties to this case are primarily found to be Bangladeshi citizens. Primarily found to be Bangladeshi citizens. But they are posting a claim regarding divorce tending to the Indian having not produced any valid document whereby they were granted Indian citizenship before proceeding this case. Unless this document was produced, will not proceed the case. In this case, any further, both sides are directed to produce their documents of citizenship
By the order impugned.
will not proceed.
Otherwise, there is no necessity. Without hearing them, I cannot do that. Yes, next.
Number 29.
Yes.
Lordship, I appear for the petitioner. Item numbers 29 and 30, Your Lordship. Same issue.
Yes. What is the issue?
It started under the Provincial Insolvency Act 1920.
Yes.
It has been repealed by the Insolvency and Bankruptcy Code of 2016. Section 243. I just indicate
Which is the order under challenge?
the orders under challenge, Your Lordship. Your Lordship comes page number 22.
Yes.
The main orders that are under challenge are at page numbers 24, 25. But I'll just take Your Lordship to the history.
27th of March. This is the order under challenge.
27, page number 24. Page number 24. 20th January 2025. And
Where is the certified copy?
Yes, Your Lordship.
Where is the yes?
Yes, Your Lordship. Page numbers 24 and 25.
Yes, please give me a minute.
Yes.
So you are aggrieved by the direction for withholding the amount.
That I'm certainly aggrieved by. Your Lordship,
Yes.
point is proceedings under a repealed act are being continued.
Yes.
These proceedings are not maintainable in law. They cannot have any legal existence. I hand up to Your Lordship section 1243 subsection 1 of the IB. Lordship, I beg to place the Presidency Towns Insolvency Act 1909 and the Provincial Insolvency Act 1920 are hereby repealed. Here, I can show Your Lordship the causes of action also, even if they allege that the proceedings did not start.
There is substance in the argument of the learned advocate for the petition.
The insolvency case number 12.
Insolvency case number. Yes. Call the next matter.
Number 31.
Yes.
Item number 31, I am appealing to the petitioner. The council appealing the petitioner is not keeping well. Lordship will kindly not take it up this week. I am not briefed in the matter.
My lord, I have instruction to appear on behalf of the opposite party. Can I direct them to have copy of it?
On the pair of the learned advocate for the petitioner, hearing of the civil division application.
Item number
A
32.
copy.
I've said copy within a week. Yes.
Item number 32.
Yes.
My lord, this is challenging the, my lord, order of alimony pending. I am the husband, my lord, 65% is a disabled person. My lord, the learned court below, without appreciating the affidavit assets, comparing the financial status, even without the considering the award monetary relief awarded by a jurisdictional magistrate in a domestic violence ex parte. My lord, pass this award, my lord. Even I can demonstrate, my lord, from the affidavit asset filed by the wife, which has mismatch about his expenditure, which has been stated, and the, my lord, statement of its accounts, of our accounts. Marriage took place 2019, 2022 due to CVA. I was paralyzed, and wife left and filed one after one litigation, and my lord, divorce filed by the wife.
No alimony granted.
My lord, observation is that, my lord, there is any ground to award the petition any monetary relief more than that award given by the learned magistrate. So the award was 10,000. And right, the India, my lord, DB my lord, monetary relief stood at 3,000 for the my lord, accommodation and 7,000 for the relief. Now, my lord, she is residing at her paternal home. She left me when I was suffering from sickness and I am paralyzed in the year 2022. Should fight with her. And my lord, the expenditure which has been 52 column number 7 in my asset is mismatched with 54 where his expenditure is demonstrated at 50,000. Whereas his total there is no harmony in this matter order impugned.
Yes.
My lord.
So the section 24, no alimony has been awarded on the ground that some amount has been awarded. How can you be aggrieved by that?
My lord, yes, my lord, this ordering portion, my lord, kindly see the ordering portion.
Yes.
That the petition under section 24 of the Hindu Marriage Act is allowed to contest.
Sir, under the magistrate has passed 7,000 as maintenance, 3,000 for rent. That is 10,000. Please kindly come to the last sentence prior to the ordering part. This court does not find any ground to award the petition any monetary relief more than the award given by the learned magistrate.
My lord.
So that's how are you
I'm
agreeing?
bowed down before your lordship, my lord. By the learned court below is, my lord, can you clarify this one, my lord? I will clarify this one.
Let a copy be served. I am not on caveat, but let a copy be served, my lord.
Yes, what is the impugned
Degree
order?
was passed, partition degree was passed in 2010.
What degree?
Partition, preliminary decree. Sorry.
Partition.
Preliminary
They are the
decree.
co-sharer.
They are not the electricity, but not the co-sharer.
So
Within the family,
how the why the
now they entered into the land, saying that this is the land acquired by the electricity board, and they filed.
What is the order impugned? Show me that.
No, they have filed one section 5 which has not been disposed of. They have challenged the appeal decree. Then they have preferred this appeal. After
Where is the decree? Where is the decree?
Decree though? Show me the decree. You have given me the brief all of a sudden.
So section 5 is pending.
Section 5 is pending for last 13 years.
So I am directing the section 5 to be
That will
disposed of.
suffice.
I will direct, but let the copy also.
Give him a,
I know.
give him a copy, otherwise
No, I know. Lordship.
he will be affected. This application under Article 227 of the Constitution.
I'm grateful.
That's for yes.
My lord, I am appealing for.
Yes, yes.
My lord, appellant tenant is the petitioner before your lordship. Appellant tenant is the petitioner before your lordship. My lord, in a suit for eviction, decree has been passed. My lord, title appeal has been preferred. Stay application was taken out. My lord, there, my lord, occupational charges. My lord, 40 rupees was the rent. My lord, without any application, my lord, without any reason and without any assessment, my lord, it has been straightway made 3,000 rupees. Kindly seize the
What is the suit property?
suit property is 160. My lord, kindly seize the photograph of the suit property.
For
I have annexed
photograph, I will see later. So what is the extent of your occupation?
160 square feet, my lord, tile shed, my lord, no flooring, no roofing.
It's very difficult to stay in that room.
No, it's not a, it is a small grocery shop. Small grocery shop.
Difficult to run a business of.
Uh,
Please vacate. Please get an alternative accommodation at a
Yes,
lesser
my lord.
rent you will get.
So far as the occupational charges, my lord, I am saying, but I shall have to pay the occupational charges. But my lord, 3,000, kindly see the order into my lord.
You are exploiting for commercial.
Let them come, my lord. No, no. But if your lordship will kindly have a look for once. I beseech your lordship, you also will pass an order, my lord. Kindly do not, my lord, have take hold of an opinion on previous issues. This is the position. Well, I know, my lord, what goes with the tenants, but kindly page 40.
So, Mr. Rai will get a better accommodation at less than 3,000.
That
Why are you saying that?
My lord, he will not be able to. My lord, 75 years, my lord, he is running. My lord, this is very marginal. My lord, kindly see
That is why. Why you will pay with 3,000? Don't pay 3,000. Get an alternative
My lord,
accommodation.
will take some time. My lord, the appeal is there. My lord, they have paid for on the ground of reasonable requirement.
How much is the market rate of rent there?
My lord, that, my lord, rent is, my lord, at best, my lord, I have taken instruction, my lord, is 1,000 rupees.
1,000.
So far as this
So
condition.
don't pay 3,000. Please fetch an accommodation. 1,000. How much time you require? I will give you that time.
My lord, let the appeal be. My lord, let me come. Come back. My lord, there is no area.
If they
My lord,
come,
she fix my lord identity. My lord,
Mr. Rai, if they come, it will be enhanced. They will take out an application, challenge.
My lord, they have not taken out any application. Kindly freeze the tenant of the order. It is not on their application. My lord, I have prayed for stay, my lord, it was fixed for ex party. Thereafter, my lord, they appeared, my lord, they said that they appeared, and the,
so this is the interim.
Yes.
Interim.
Not interim, my lord, the stay of the, my lord, kindly seize the order in till the disposal of the appeal. Order number 6, my lord, 24/6/20. My lord, kindly seize the order.
Mr. Rai, you are taking the risk.
No, my lord,
if they come.
If the valuation goes, my lord, if my lord, I am, my lord,
What is the document you have produced to show that the rent is 1,000? Show me.
No, 40 rupees was the rent. I am not.
40 rupees, forget about that.
I, my lord, kindly seize, my lord.
Mr. Rai, that was before Akhtaram came into force.
Yes, but I'm not asking, my lord, that it should be 40. I am not saying that, but I am ready to pay, my lord, subject to your lordship, for whatever commences from your lordship. But 3,000, the findings, my lord, why not it is 3,000? Why not it is 2,000? My lord, kindly seize the order, my lord. The order, what is the tenor of the order, my lord? The court simply says, hence, this court is now pleased to pass an order and to of occupational charges at the rate of 3,000. Directly, no, my lord, no, my lord, it is not their application, neither did they apply, neither did we get the chance, my lord, to have an assessment, my lord. Your lordship will.
So, this quantum was fixed without hearing them.
No, they appeared. They appeared.
So, why are you saying it's ex party? Maybe, Mr. Rai.
My lord, the order has to be, my lord, the order, my lord, your lordship, my lord, if your lordship sees the order, there is no findings, my lord, the valuation, assessment, value, my lord, there has to be a minimum, my lord, subjective assessment. Court has to, my lord, assign some reasons, my lord, it is nothing. I shall, my lord, your lordship, direct ask, my lord, to give the valuation, my lord, I shall come back to your lordship. Your lordship, direct ask, my lord, to have an assessment, I shall produce before your lordship. What should be the valuation? If I have no case, my lord, I will have to go.
Anything more?
My lord, kindly give that chance.
Anything more?
Otherwise, my lord, I can, my lord, for 75 years, my lord, I am. The appeal is pending, my lord. They have not filed a caveat, my lord. They are not interested.
Mr. Rai, appeal may be pending, but you have to pay occupation charge.
I can never say that, my lord. I am only insisting, my lord. It should not be 3,000. My lord, let it be whatever commences from your lordship, but at this moment, not.
The situation has now changed. Prior to Akhtaram,
yes,
the landlords were rushing before the courts for expeditious hearing. Now it's the reverse. Now the tenants are rushing. Please expedite the hearing of the appeal.
No, that is there. That is there. An occupational charge.
Are now saying no. Let the appeal be.
That is
due courts. So now the tenants are.
I am. But occupational charges, but I have to pay. I have to pay. I will have to. I am ready to pay.
The decree was passed.
Well, decree was passed, my lord. This is the on December 24.
December
24.
December 24.
Lordship.
So according to market rate is 1,000.
My lord, without any assessment, I am saying
market rate is 1,000.
Very honest, my lord. Whatever I have got the instruction. But my lord, I would beseech your lordship and let there be direction for having an assessment because.
So deposit 20,000.
20, my lord, he cannot pay 3,000. That's why he has come before your lordship.
Planet trial judge has said 3,000. You are saying 1,000. I am making it an average of 2,000
from the January.
Yes, from January. So July is already over. So August it is being fixed. Please deposit unconditionally. There will be a stay. Please deposit within 15 days. I will direct service. Upon hearing them, I will finalize the But show your bona fide by deposit.
Lordship,
It is in 2 weeks deposit 20,000. I will consider the rate.
My lord, the court, yes, my lord, I bowed down before your lordship, but court below granted time, my lord, till the next date was on August.
Next date is for hearing of the
August.
appeal.
Yes, and the payment of the arrears was directed. My lord, only some. I cannot but.
So 3,000.
That was 3,000. That was 3,000.
That is the why
No, I should not.
2,000.
My lord, then my lord, 3 weeks, my lord. Possibly, my lord, but some lord. Yes, I shall not bargain much more, my lord. Then my lord, kindly give us 3,000 and 3 weeks conditional stay, my lord. And that.
This is the market rate. 3,000 it came out.
Oh, 3,000. I have no problem with that. Exactly, my lord. I have said so. My lord, it was not out. Never.
Because that was the instruction from your client.
Never, my lord. Otherwise, you my lord, kindly sees the nature of the shop. Your lordship will understand. My lord, your lordship has enough experience, my lord, but I have.
I do not have any experience.
No. That, my lord, we have seen. And my lord, your lordship kindly sees, my lord, the picture. Otherwise, I would not have, my lord, pressed upon your lordship. Kindly sees the picture of the
picture outside.
There are people, my lord, who cannot survive.
Mr. Rai, outside picture is one thing.
No, inside is given. Inside also I have given.
Inside is
page 40 is the inside picture.
Altogether.
Page 40 is the inside of the. There is no hide and seek.
Property.
There is no hide and seek.
Where is the property?
My lord, in Uttarpada.
Uttarpada.
Yes.
How soon can you serve and come back?
No, within a week. How soon can we serve and come back? Within a week.
Within a week.
We shall serve it by tomorrow only.
By tomorrow.
Definitely.
Mr. Rai, learned advocate. That is the risk you have taken. So be ready for enhancement also. Yes.
But your lordship is satisfied.
Yes. None appears for the petition at the time of call. No accommodation has been. Yes.
In this matter, my lord, what happened? The petitioner filed, my lord, a partition suit. And thereafter, my lord, a preliminary degree was passed. And there is direction.
What is the impugned order?
Impugned order, my lord. That was page 78 and 79. Survey commissioner submitted report.
Yes.
And I filed a objection, and that was not heard. Actually, my lord, on the date fixed, my lord, 4th April 2024.
Yes, what happened on 8th of April?
8th of April, my lord.
Then also you did not appear.
Yes, my lord. Only
so
I was, my lord, ill. I have annexed my lord medical certificate, and date, my lord, kindly see on 4th April 2025. I was absent and I was ill and suffering from typhoid. I have stated in paragraph 10 and 11. Thereafter, my lord, after 5 days, my lord, another date has been fixed. And I have, my lord, objection, and that is also pending, my lord.
You are asked to show cause. You also did not appear on the next date.
So called, my lord, on that date, actually, I was ill. And after 5 days,
file a show cause. On 4th of April, you did not appear. Thereafter, on 9th of April, also you did not appear.
Due to my illness, my lord. Only after 5 days.
Take out an application before the learned trial judge. for setting aside of that. How do I know that you are ill or not?
I have annexed, my lord.
That cannot be decided here.
And I have annexed, my lord, my objection also, my lord, it is pending, my lord.
That is
And
already there.
the report is actually, my lord,
Objection may be there, but you have to consider, you have to make submissions on
report
that.
is, my lord, I have challenged the report that is beyond, my lord, the scope of preliminary degree, my lord. There is
Yes.
direction to actually ascertain the plot Co-A, but that has not been done, and no valuation has been assigned. So, my lord, it is actually pending, and a physical hearing may be, without giving any opportunity, my lord, it has been passed, my lord. So,
Whether it's an appellable order or a revisable order.
no, my lord, no, it is no degree has been passed.
That is the ministerial job. The what remains, commissioner's report accepted. What remains for passing of the other thing is the ministerial job.
Accepted, my lord, that is, my lord, I have come before your lordship, my lord, that is why. Actually,
Where is Mr. Partha
one
Pratim Roy?
opportunity may be given, my lord.
Where is Mr. Partha Pratim Roy?
Opportunity may be given, my lord.
Yes, I'm passing it over.
Matter is disposed of with a direction to the office to draw the final degree.
All right, I'm
As-
passing it over because please consider whether it's appellable order or a revisable order. There are decisions on this.
Tomorrow.
Yes, next. All the next matter.
Tomorrow, my lord.
Item number 37.
Yes, if you can find Mr. Partha Pratim Roy, please ask him to come. You know him?
I will find it.
Call him.
My lord, item number 37, I'm instructed to appear before your lordship.
Yes.
My lord, the advocate on record is unwell and she is unable to come to the court, my lord. If your lordship kindly fix next week.
On the prayer of the learned advocate for the petitioner, hearing of this matter.
Grateful, my lord.
I'm for the opposite party.
Yes.
Well, I am for the petitioner.
Yes.
Well, kindly see the order sheet. The very first order dated 18/4/20.
Impugned? Which order you are challenging?
Well, order impugned is my order dated 28 January 25 and 11/2/25. Last two orders.
Yes.
Well, kindly come from order dated 18/4/23. The order sheet, first order, 18/4/23.
Yes.
Milo got it. 18/4/23 was the first day when the evidence chief was tendered.
Yes.
And 2-line cross-examination and adjourned.
That was recalled.
Yes, my lord.
Milo, kindly, Milo, my submission, Milo, I am suffering. Milo, 18/4/23, so very one was examined, that 2-line cross-examination was given and added to adjournment. Thereafter, long 1.5 years, judge was vacant. Next date came on 21/24. Only that day, untimely rain, I was suffering from illness, cough and cold, I paid adjournment. That was rejected. On the same day as none moved, on 21/12/24. This is the first effective date. Order dated 21/12/24. Order number 98.
Sir, you have challenged the order dated 11th of February 2025. What is the infirmity in this order? Please tell me.
Yes, my lord. So thereafter, I came on 7th January 25 with an application for allowing me to cross-examine before the next date. Before the next date. So that was not taken up on the date fixed 28/1/25.
Your prayer for recalling was allowed.
Yes.
Subject to payment of cost.
Yes.
Yes. So why are you aggrieved? Your prayer was allowed.
But I cannot pay the cost. But
why?
Why? Well, first of all,
you cannot pay the cost. Then everything will go. Don't cross-examine. The order, part order you will be accepting, part not accepting will not help.
Allow me to make
either you accept in total or it will go.
My lord, I relied upon
that portion of the order which benefits you.
No, this is my diligence. It's last Supreme Court said could support the diligence, not the indolence. So only on operation, I put the adjournment formants and the next after working on the I moved the application along.
What is the cost incurred for approaching this court?
Yes, ma'am.
My lord,
I'm asking, what
this
is the
is,
cost your client had to incur
my
for
lord,
approaching this court for filing this eviction application?
my lord, this is the case of a junior. Ovip Sir is the advocate in the Alipur.
I'm asking you, what's the cost involved?
My lord, 222, 222 my lord, court fees. No, I am taking department amount of cost. My lord, cross-examining was recalled only for one occasion latches and very only not that I am taking time for long time. So they are out. And my lord, cost.
2006 my lord eviction.
Insisting on cost.
Was not only that, my lord.
Are you insisting on cost?
Let kindly see their conduct once. Thereafter, Manoj, what?
Allow me to
I'm asking you, are you insisting on cost? Yes or no?
Yes, Manoj. Yes.
Why?
Manoj, if Manoj kindly see their conduct, Manoj, 2006 eviction suit.
I appreciate that.
Manoj, because Manoj,
I'm expediting the suit.
Manoj,
I'm expediting. What is the next
only
date?
at the stage of argument.
Manoj, 11th
Only
August,
at the
Manoj.
stage of argument, Manoj, they have Manoj to kindly see.
What is the date of argument?
11th August, Manoj, 11th August.
Sir, I'm asking him.
Manoj, because Manoj, your lordship has granted an interim stay. That is why Manoj, the date has been fixed on 11th of August.
Yes.
And Manoj, kindly Manoj, see their conduct. Manoj, this is a 2006 eviction suit on the ground of second default. Manoj, their Manoj defense has been struck.
I'm expediting the suit, sir.
Manoj, and not only that, Manoj, Manoj, kindly see, Manoj, they have challenged the order of 11th February. Manoj, thereafter date has been fixed on 10th of March. Manoj, what they have done, Manoj, they have filed an application before the trial court for Manoj adjourning the matter for one month, and Manoj making aspersions against the judge. Thereafter,
Where is
they
that?
have, yes,
Show me
Manoj.
that.
Manoj, they have not annexed that.
Show me that.
Manoj,
Give me
kindly
that.
see the order of 10th March.
Yes.
This is the order, and Manoj, this is the Manoj application they have prepared.
March.
Manoj, I'm showing you
The application.
Yes, Manoj, I'm showing. This is the
Give me
application.
that application. If you are making aspersions against
No, that cannot be. What aspersion?
Where is the aspersion? Which paragraph?
Yes, Manoj. Where is the application? Manoj, kindly. Yes.
10th March. 10th March.
Manoj, paragraph 6.
No.
Yes.
The learned court itself did not fix short dates in compliance. Allegiance of the said memo dated for disposing of the suit early. The said memo definitely did not mandate to somehow dispose of the suit. And Manoj, paragraph 4 also. The advocate for the plaintiff did not appear on the date, so the application was posted for hearing and it was allowed 3,000 court fixing for cross-examination, amount payment of cost. This simple application of 7.
These are the statements made by you.
Yes.
These are the statements made by you in the application.
Let me read for a moment. Paragraph 6.
Yes.
The learned court itself did not fix short dates in compliance. The allegiance of the said memo number so and so for disposing the memo issued by the High Court. But exceedingly source. The said memo definitely did not mandate to somehow dispose the case in unreasonable, expeditious and swift manner without considering the actual inconvenience of the party. It cannot be the law in a democratic country to disentangle and deprive a litigant.
Right, sir. Yes.
And my lord,
Thank you. Anything more?
Anything
After
case,
this
my lord.
application is not-
Yes, I am saying. My lord,
Sir,
I relied upon
you did not cross-examine. You prayed for time, adjournment.
no adjournment, only one occasion. My lord, we are human beings.
Subject to payment of cost of 3,000 and you are making these allegations
Man,
against the aspersions against.
My lord, this is not
Officer.
this is not allegation. This is not allegation. My lord, see, kindly, after closing my evidence, there are 5 days fixed for the argument of plaintiff. My lord, kindly see.
All right.
After closing the evidence, 5 days have been fixed for the argument of the plaintiff.
Do you want to cross-examine? Please pay the cost or I will.
My lord, I want to process and my lord, there is law.
How much time you want to pay the cost?
My lord, I cannot pay the, my lord, I let me so much two judgments. Let's say judgment.
Yes, so
My lord,
cost may escalate. Cost may escalate. Cost may escalate.
My lord.
Side judgments also.
Down. Madam, referring on the judgment, Delhi High Court, for cost of to consider section 35B, is the cost for taking obtaining adjournment. That is only the traveling cost by attending the other side.
Set aside everything. I will set aside the order. I will say yes. You will not cross-examine also.
And my lord, 35B.
I will set aside the cost as well as you allowing you to cross-examine. Both will go.
My lord, just a minute, my lord. So 35B. For a moment. Yes, there is section is that court may reasonably sufficiently reimburse the other party in respect to expense incurred by him in attending the court on their court, and cost is not a penalty that is decided by the Delhi High Court. And that means, next, my lord, the provision of subsection 2, the cost, if not paid by including the cost awarded, and if such costs are not paid, a separate order shall be drawn up indicating the amount of such cost and the names and address of persons by whom such costs are payable. The orders should drawn up, so that is the at the time decree, the court can prepare a sheet. This cost is liability paid by defendant, but court cannot be denied to me. It is a integral part of the natural justice guaranteed by Article 14. And my lord, I have judgments, my lord. Said the cost is not equal with the penalty. Therefore, definitely penalty would have been used. No, this cost means actual cost, and in this judgment, the cost is 2,000. Only travel expense witness travel for Durga to Delhi. That cost 5,000 is not paid. The only travel cost. And my lord, next, in another judgment, Supreme Court 508, 2010, Supreme Court 508. Here also, the witness. Yes, they also yes. This is and another judge has shown this is 5,000 rupees, 2,000 reduced to judgment. In both the judgments, the witness had come all the way from Durgapur to for giving evidence. Therefore, cost. And the person next transfer to another court. 5,000 cost. Therefore, the cost implies the actual cost incurred by the party to attend, and not only that, on the day not recorded the order of the adjournment. Yes, my lord. Can you see both the judgments?
Not only that, I have shown your lordship the order dated 10th of which their argument has already been closed. They have not challenged the order. This has been filed subsequently. 10th of March order I have already given. 10th of March I have already given to your lordship.
But long 1.5 years, they did not move the judging charge. Long 1.5 years. Only one suggestion I
Accordingly, the petition filed by the defendant is rejected. On being asked, the honorable advocate for the defendant expressed that he will not argue the suit as he sought for adjournment. Accordingly, the argument for the defendant is closed. The record is taken up for argument by the plaintiff.
All right. Anything more?
No, not more.
Tomorrow for orders.
So cost is only rupees.
Cost advocate for the parties. Is call the fixed matters.
What happened, Mallo?
Tomorrow I will pass orders. Be present tomorrow.
Mallo, not tomorrow. No, tomorrow is my wife. Radiation will come. Day after tomorrow. But day after tomorrow.
Present, I will only pass the orders. Hearing is concluded. Yes.
I'm record my submission. I am ready to cross at any day. Or even tomorrow, it will only 20 minutes to cross examine on my part.
Yes, that I will consider.
Item number 175.
Yes. If this is concluded, then I will return because some fixed matters are there. Yes, who is appearing?
Yes, lordship, I am appearing with the petitioner, lordship.
Yes.
As a fact of the case, lordship, I am the plaintiff number 1.
The order under challenge.
Under challenge, the impugned order application under section 10 was allowed by
stay of suit.
Stay of the execution proceeding.
Why?
That is my impugned order, lordship. So that I place the factual aspect initially, lordship.
Sorry, I left the note on.
Yes, what is the ground for stay?
Nothing was mentioned, lordship, and also my point is that section 10 is not applicable by staying the execution proceeding.
Where is the application? Where is the application?
Application, lordship, application section under section 10, lordship, page 991.
Why stay was paid for? What is the ground?
I don't know.
So what are the facts?
Fact is lordship. My client is plaintiff one and my brothers plaintiff two file a suit for declaration and recovery of possession and mandatory injunction. Suit was decreed. During pendency of the suit, before argument, plaintiff number two transferred his share to the present opposite point number 1 to 19. Suit was completed and passed the decree. I put the decree for execution. In the execution proceeding, opposite point number 1 to 19 come and file an application under Order 21, Rule 97 to 101. And also file an application under Order 39, Rule 1 and 2. And also file an application under Section 10. They are claiming
basically stay of execution.
Stay of execution. They are claiming
stay of execution because this case under Order 21 Rule 99 is pending.
Yes.
That has to be stayed.
In the Order 27 application under Order 27 is specifically stating that they purchase from the plaintiff number 2 so that they are also beneficiary of the decree.
No, Order 39 Rule 1 and 2 date was fixed. This stay, if it is not granted, so what will happen to the miscellaneous case?
Section 10 cannot be applicable.
Maybe. Section 10 may not be applicable. Section 151.
Yes. Logic, kindly see the application under.
I can expedite the miscellaneous case.
Logic, only one thing, Logic. Application under Order 21. Kindly see. They specifically were claiming that they are.
But I cannot decide from here.
No. They are specifically claiming that they purchased the.
File an application that this miscellaneous case is not maintainable. File an application there.
Then kindly direct the code below to expedite the Jamie's case.
Thank you. This application under Article 227 of the Constitution of What happened to that matter?
That has been fixed by your lordship.
When?
Next week. Next week.
What is the date?
24th of, that I'll supply to the date to my land court officer. Final degree acceptance of commissioner report.
You have served the other side.
Yes. Yes. That has already done. Mr. Mukherjee has also been briefed.
তাহলে ওই এটা একটা করে দিন এইটাকেও না নাম্বার 36 একটা অর্ডার করে দিন ফাইলটা দিন Please tell me the yes. Stay. Three to six, yes. Who is appearing?
We are for the opposite.
You are for the opposite party. Who is for the petitioner? This matter was mentioned by the learned advocate for the petitioner citing urgency.
I am for the petition.
Yes.
By the order impugned, my lord, an application for devolution of interest is being allowed in a suit for eviction.
Appellable order.
But kindly give me liberty, my lord, to approach. But may I take back
This application under Article 227. Yes.
This is, I am for the defendant opposite party,
Yes.
defendant petitioner.
You are for the defendant petitioner, yes.
The order passed under order 26 rule 9.
Yes.
Admittedly, there was a degree in the previous suit, which was filed by the predecessor of the plaintiff and the predecessor of the defendant. That suit was decreed. This is a suit for.
What was the previous suit for?
That suit was for partition, and property has been demarcated. Thereafter, my lord.
What is the present suit for?
This is suit for injunction.
Yes.
And injunction, declaration and injunction. And that has been, my lord, already decided in the degree. Kindly see the schedule of the survey application of order 26 rule, page 53, schedule. To survey the core and claim core 1 and core 2 scheduled lands with entire sub-ex plot 64, hull plot 66, measuring a total area 19 decimal, and sub-ex suit plot of 65, hull plot 67, measuring total area 5 decimal of Mouja, Sherpur, Kharkiba, jail number so under Kontai municipality as described in the plaint.
Yes, this is a suit for mandatory injunction, alleging encroachment.
Alleging encroachment that he has, my lord, stated that it has been.
So in such a suit, local investigation is necessary.
But
without local.
But at what stage, my lord? There is no evidence was at present not adduced by any parties. And this is the after filing written statement, this application was filed. Where, my lord, kindly see the schedule of the investigation.
Yes.
That and draw the same in the case map after relying the corresponding settlement map 1934-37 or 1954-57. Now kindly see the degree, which is at
No, decree.
Degree in respect.
Decree is that allotment has been made.
And so, there is a schedule.
Yes. So now whether there is any encroachment or not, order 26 rule 9 has to be allowed.
That should be, my lord, when it has been identified by the plaintiff.
How that can be identified without local investigation?
They stated in the plaint that core 1 is a part of.
Sir, that is on documents. Core 1, this is part. According to, please kindly come to their prayer. They have alleged encroachment of that core 1 and they have sought for mandatory injunction. So if it is not with that part, no decree will be passed. That will be for your benefit also.
No, that is what they are trying.
Have you encroached upon that? Have you encroached upon that property?
No, not at all.
So nothing will happen. Let the local investigation be done. So it will.
Only difficulties is it will, my lord, create another problem because it will differ the degree. Kindly see
cannot differ.
Kindly see page 28, my lord. Kindly see page 28.
Yes.
This is the part of the degree.
Yes.
And here, my lord, that is 27, starting from 27, Dittiyo Pokko Bhobesh Chandra Mainti. This is the father of the plaintiff.
But these are the allotments of the respective parties.
Allotment, and it is the degree, and that has been acted upon.
Nobody is disputing that. Now they are saying that you have encroached upon that property, their allotment.
If that be so, in why they have in the schedule, they have, my lord, kindly see the schedule of that.
So that will be decided. That will be decided at the time of hearing of the suit.
Kindly consider only once, and kindly consider to survey map on the basis of 1934-37. They are relying upon that, but it is in the degree. It has been stated that such plot is bounded by such and such. Kindly see the degree. They have, my lord, kindly tried to change that degree schedule.
Yes. This application under.
Therefore, my lord, kindly let them say what is the purpose on decision, my lord. Only two decision I have in support of this. Kindly see what stage he has, my lord, asked for. That is at one Karnataka judgment.
Is it binding?
No, not binding. I know, but what is the stage of the case?
Show me from the statute. What is the stage?
Only both plaintiff and defendant filed their written statement. Thereafter, the plaintiff filed this application.
Show me from order 26 rule 9. It's what it says at which stage.
Yes.
Please show me whether it has said anything with regard to the stage.
In any suit in which the court deems a local investigation to be requisite or proper for purpose of elucidating any matter in dispute.
Yes. It does not say that after this stage of evidence.
So
where from this has been done?
Well,
any other decision you want to cite?
Another decision is that is also Himachal Pradesh. This is not on but paragraph 9.
You have not brought the contrary judgments, which says at any stage that you have not brought.
Here the case is similar. The appointment of advocate commissioner.
Where it has, this is also that it has to be evidence.
Yes, no. The appointment of advocate commissioner is only on the aid of the court to assess the evidence laid in the both parties with respect of the dispute.
Yes, no dispute on that. This is well settled proposition. This is well settled. No dispute on this. But stage cannot be. This application under Article 227 of the Constitution of India is at the instance of the
For 612.
But I am for the petition.
Yes.
I am appealing for
Yes.
the present application, my lord, in a suit for recovery of possession from the persons who have been
Is that affidavit
This
service?
is the affidavit of service.
Yes.
My lord, in respect of a suit, my lord, for recovery of possession from a persons who have been their right to reside in the suit premises has been extinct in view of the fact that the death has occurred, my lord, to the person.
What is the impugned order?
My lord, by the impugned order, my lord, by admitting the fact that there was a suit, by virtue of which, my lord, I have withdrawn, stating themselves that they have inherited the tenancy.
They have
inherited the tenancy.
Yes.
My lord, subsequently that suit has been withdrawn, and my lord, since the statute, we have stated in the plaint itself that we have withdrawn that suit, and we have filed the present suit, my lord, on the strength of the fact that the statute, there cannot be a estoppel against the statute. Their right to reside in the premises has extinct. My lord, in such a suit, my lord, the petitioners has been examined, cross-examined. Thereafter, an application has been filed for bringing of these records of the case of earlier suit. Although I have filed the documents in support, the court has allowed such application, my lord, that these documents are necessary.
Where is
So
where is their application?
My lord, kindly look into annexure C, page 23. My lord, kindly turn to paragraph 5, that during the course of cross-examination, namely Srimati Mousumi Arjo, she was asked to file certified copy of the plaint. My lord, they have also admitted that they are the tenant, they were fighting that suit, my lord, and the suit is barred by the present suit is barred by limitation because the extinct. And we have filed, my lord, the necessary documents in support of our claim that the earlier suit has been withdrawn and the present suit has been filed in support of such application. And my lord, this has been admitted that we have instituted suit. And my lord, the court has allowed such application and thereby deferred till date the record has not been reached to the court, whereupon the court has. And now, my lord, in such a way, my lord, an eviction suit has been deferred.
Where is your plaint?
The plaint, my lord, I have stated also plaint.
Show me that you have stated this fact.
My lord, kindly turn to pay. I am giving, my lord. Paragraph 7 at page 13. It is stated further by the plaintiff that her father earlier, unfortunately, because of wrong advice of his then learned advocate, learned lawyer, Sri Bhushan Saha, advocate, had unknowingly and or erroneously admitted the defendant together with their said other brother, Samlal Chaudhary, since disease as the alleged tenant by inheritance. From their said disease power, Yashodananda Chaudhary, in respect of the suit premises, and thus had given the said letter of reply dated 19 to defendant Bhogas and later of the month of July, as well as the earlier eviction notice dated. And thus, out of such misconception of law and wrong advice of his said lawyer, Bhushan Saha, he had filed an eviction suit earlier, being titled suit number 76 of 2011 in the learned court against the defendant, and said Samlal Chaudhary, since disease, whereas after his demise of father of the plaintiff, he, after being substituted in the suit, that is titled suit number, had withdrawn the said suit by the order of the learned court dated 7 February 2000.
But where is the plaint of the earlier suit?
The plaint of the earlier suit, my lord, that certified copy is not there, but we have furnished that copy of the earlier suit.
But why can you not obtain the certified copy?
My lord, because of the fact that the earlier suit we have withdrawn, we have that.
No, Mr. Mitru, that you can withdraw that, but there is no difficulty on that. But they are trying to say that since you have admitted them to be a tenant.
Yes.
So where is the, why can you not file the certified copy?
My lord,
If
this
you can file the certified copy,
my
I will
lord,
give you
the
leave.
certified, the record is not available of that suit. Therefore, we could not file. We have, my lord, also annexed the applications under Order 23, Rule 1 that was filed before the court. The order passed by the learned court. And my lord, they are
The summons, it states in the earlier suit, summons was served upon them.
Summons was served upon them. They appeared, and before
They appeared.
They appeared.
Yes.
They were
Statement not then made application under 7172 of the West Bengal.
You filed an application under section 7172. So you must be having the copy of the plaint. You are having the copy of the plaint.
And my lord,
you have the copy of the plaint. You have been served with the summons in the earlier suit. So produce that copy of the plaint. You want the copy of the plaint to be produced. So I am giving you liberty to produce the.
They have filed a written objection in 7172.
Yes. So you are also having the copies. I will direct both of you to file copies. Mr. Mitra is having copies. You file your respective.
That if that is with us, my lord, that we shall file.
Huh?
If that is with us, my lord, we shall file.
Do that. Yes, call the next matter.
Item number 681, 68.
My affidavit of service be kept with the record.
681, 682, 683, yes. Yes, analogous matters. Yes, what is this matter? Why can?
Can one during pendency of application bank put padlock. Second can the bank already sold the property, and 12th and 12th.
What is this impugned order? What is the impugned order?
Impugned order refusal of injunction, both the court, kindly see last order passed by the learned additional district judge.
Ad interim injunction is refused. When it was refused? 2024.
2024, but that matter is pending, earlier, so moved and.
So I'm directing the miscellaneous appeal to be disposed of.
But that on 12th, the who purchased the property, thrown the goods from the shop. I lodged.
Now, ad interim order cannot be passed. So it was in July 2024, and the learned trial judge also refused when 5th of July.
This honorable court directed to serve the notice to the bank. But then the matter is pending, the list.
Where is the notice for upgradation?
Already, kindly see the
Yes.
I mentioned the matter.
Who is appearing for the bank?
The bank, not yet. The bank already sold the property. Another writ petition, another the party, another shop owner file a writ petition. That writ petition they submitted, they sold the property.
What is the stage of the miscellaneous appeal? I am directing the miscellaneous appeal to
miscellaneous appeal pending, because I file a revision application pending.
Or I can do one thing. What is the stage of the temporary injunction?
Temporary injunction,
also pending.
Pending.
I think it's better if the temporary injunction is disposed of. Nothing, no ad interim.
If
almost 1 year.
Thrown out the 12th, but I lodge a complaint.
Mr. Mukherjee, for 1 year you are without any ad interim order.
This is my fault. This is.
I'm not saying your fault, but
I am not bank already put but only status quo, only status quo.
Status quo without indicating the status.
If the bank put the padlock, if these promoters who purchase the property, if the demolition.
What is the stage of the miscellaneous appeal? What has been done?
Miscellaneous appeal is pending.
I'm directing the miscellaneous appeal to be disposed of.
But without then
you are without any interim order for 1 year. I'm directing to dispose of. What is the next date fixed in the miscellaneous appeal?
I do not know. Probably August.
August. I'm directing the this application under Article 227 of the Constitution of India is at the instance of the plaintiff and is directed against an order being number 3 dated 5th of July 2024 passed by the learned additional district judge 2nd court Balasat district 24 Parganas North in miss appeal number 84 of 2024. Where is the plaint? The petitioner filed a suit for?
A suit for the declaration of title and injunction.
File a suit for declaration of title and permanent injunction. So, stop in such a suit, the petitioner. You have also not annexed the order of the trial court.
Yes, also annexed.
Where? Which page?
Page 33, my lord. 31.
Kibala, in such a suit, the petitioner filed an application under Order 39, Rule 1 and 2 of the Code of Civil Procedure, and the learned trial judge, by an order dated 28th June 2024, rejected the ad interim prayer for injunction. Being agreed, the petitioner preferred a miscellaneous appeal, being miss appeal number 84 of 2024, and prayed for an ad interim order of injunction. First up, the learned additional district judge 2nd court Balasat district 24 Parganas North, by an order dated 5th of July 2024, refused to pass an ad interim order of injunction. First up, this matter is pending since this matter is pending before this court since July 2024. First up, however, considering the fact that the learned trial judge and the learned judge of the first appellate court refused to pass an ad interim order of injunction. This court is of the considered view that the interest of justice would be subserved if the learned judge of the appellate court is directed to dispose of the miscellaneous appeal as expeditiously as possible. Full stop. As expeditious to dispose of the miscellaneous appeal expeditiously. Full stop. Paragraph CO number such and such stands disposed of by requesting the learned additional district judge second court Balashat to make an endeavor to see that the miscellaneous appeal number 84 of 2024 is disposed of as expeditiously as possible without granting any unnecessary adjournments to either of the parties.
Oh, certain time,
What is the next date fixed?
August, probably August.
Have they appeared?
No, not yet appeared.
Then how can it be fixed time?
No,
Can be
with certain time, 2 months or then the promoter demolish.
within a period of as expeditiously as possible, but preferably within a period of 4 months from the date when the miscellaneous appeal is made ready for hearing. Yes, next.
Item 822.
Next, same.
All.
Only the miscellaneous appeal numbers and the suit numbers, same order, কিন্তু separate করতে হবে. Separate হইবে. Yes, next. 822.
82 and 83, all are
822. No, 681, 682, 683. These are same. 822. Who is appearing? And what are the applications?
My applications, one application smaller, for the due pendency of the bank put the padlock, and second after purchasing, who purchased the property, that person will be included as such addition of party.
Addition of party.
Addition of party because order of at present bank has no interest. Bank sold the property.
Applications disposed of. Yes. Yes.
That addition of party can be allowed because the first appellate court, then
You have to take out an application. You have to take out an application for একটা order record করে দিন. None appears for this matter was mentioned citing
Item number 878. This matter, I am praying accommodation.
কালকেও নিলে তো
কালকে না পরশুদিন
this is the challenge to the award under the MSME.
Kindly.
The issue was they can't challenge in without.
Yes, why?
75%.
Yesterday you also paid for time.
No, Mr. Basu was appearing, my lord.
Mr. Basu appeared, I think 15 20
He's on leg on
ask him to come.
Court number 11, my lord.
He appeared in the matter where Mr. Mukherjee was appearing.
But he's on leg on court number 11, my lord. I have been told. Lordship.
We lawyers have to be engaged. Yes.
Lordship,
What is this matter?
What's for today's only, Lordship?
Dinesh again.
Mr. Banerjee, they are safe because I have a fixed matter at 4 p.m.
We had here.
তা দেখো আমি যখন থাকবো না তখন প্রেস করবে তোমরা।
স্যার আপনার কাউন্টার টাইম নিয়েছে একবার। Mentioned as whose instance?
Well, their
Madam, I am directing this matter to be reverted back to the original position. 2 days you will be mentioning these matters will occupy the list. He is safe. PMM matter is fixed matter.
My lord, I also could, my lord, support that, my lord, really very strongly. I don't know what would have happened to me outside. That is why, my lord.
Why?
If Mr. Basu met me and he found out that I've insisted on, my lord, the matter going out, I would have had some trouble. That's why, my lord, I also did not.
Yes.
Too much of abuse, my lord, outside maybe.
এটাকে not to decode.
Item number 933.
933 আর ডাকছেন কেন? ফিক্সড ম্যাটারটা ডাকুন। হ্যাঁ? ও 4:15. Mr. Ghosh, I have said 4:15. 4 o'clock বলেছি। Yes, Mr. Basu. Every day you are taking adjournment. Mr. Banerjee is making serious allegations against you.
See my prediction, my lord, I said, my lord, এই গ্রাউন্ডে কিছু করতে পারিনি আমি। তো মামলা করো।
Start. What's the adjournment চাইছে কি
You have missed your bus.
Oh.
Or train or flight, whatever you may say. No, bus. I should not say flight.
I cannot.
I cannot say to you bus.
You can say here, but not bus.
আমি তো আছি ফ্লাইট ধরে।
My lord, does not remember till I was given the senior advocate gown, I was not allowed to take my card to the chamber.
Yes, call the
So I
fixed
am
matter.
habituated with this.
Call the fixed matter.
I had the next matter 1034. There was a child custody matter appearing at our instance.
1034. 1034.
1034.
There is a fixed matter at 4.
Tomorrow, your lordship, anytime.
It will be taken up tomorrow. Hopefully.
8-year-old child, I am child custody matter. I was just that's.
Daily list not item number 184. It's a fixed matter at 3 p.m. Made retain his position tomorrow. Made retain his position tomorrow.
Will retain. Nobody is disturbing. Who is disturbing?
No one. Yes.
Nobody is disturbing. Yes, Mr. Ghosh.
Item number 25.
1320 of the monthly list, lordship, expeditious matter. Tomorrow.
Expeditious, no urgency. Yes.
It's fixed, lordship. The other side I was directed to be served. We have served.
All right. Yes.
দাদা আমি পটিল অটোমেশন থেকে দিয়ে দেবো? হ্যাঁ দিয়ে দেব নিশ্চয়ই দিব।
Yes, Mr. Ghosh, you are
this the judgment will the party automation will reach.
You are placing the impugned order.
Sir, I had placed the impugned order.
Yes.
Completed. The
Yes.
impugned order proceeds on the basis of paragraph 74 of party. Lordship opens, takes party paragraph 74 and the impugned order. I was reading, Millard, in the library, Millard. Millard, kindly have a look at the impugned order in question.
Impugned order?
Yes, keeping Millard para 74 of the party Millard signed side by side.
Yes.
Para 14, Millard kindly. Now, Millard, previously before Dhanbad fuels, we used to file Millard separate application. In High Court also, before Lakshmi Folifab, separate application. To more Millard detail the urgency that was filed, that was accepted, I have a copy of it. Now, Millard, kindly have a look at para 14. The observation in the aforesaid judgments, in all fairness, Millard, should be Millard, Srishti, Patil and Millard Jamini. Because Dhanbad was not there at that stage. It is post-Dhanbad. Millard, observation pre-Dhanbad of the judgment makes it clear that whether a suit involves any urgent relief has to be determined on the basis of the pleadings and the relief sought. If the plaintiff seeks an urgent relief, The suit cannot be dismissed for non-compliance of provision of 12A of the Commercial Code Act 2015. In paragraph 25 of the plaintiff has pleaded the defendant is a joint venture special purpose vehicle and unless appropriate orders of attachment and injunction without serving notice to defendant pass, the reliefs are contemplated as prayed for may become infructuous. The plaintiff for the purpose of his interim protection has filed an application under Order 39, Rule 1 and 2 of the Plaint. In the said application also the plaintiff pleaded the defendant are not restrained from operating the bank account without leaving a sum, are not restrained from selling, alienating, disposing of the property, the plaintiff will suffer irreparable loss and injury. The plaintiff in paragraph 25 has pleaded that since the parties were already before the court in a previous instituted suit. I stop here. Suit A, I say Millard, is between Millard, the parties are the same. The suit A is between a contract A, which was not completed by the plaintiffs there. Whatever be the reasons, Millard, they filed a suit.
It was not completed by the plaintiff.
By the plaintiff. The plaintiffs are the contractors who has filed the suit. Millard,
So that is the defendants here.
They are the defendants here. Same defendants, and there is a name change. So, Millard, the names look different. Now, Millard, it's a JV. Now, Millard, in respect of that which they have left, Millard, according to them, the employer did not give them the sufficient workspace or whatever the contractual land, etc., drawing delayed payment. So, they had to leave the work and go. Now, Millard, in respect of suit B, which Millard, the employer has filed against the same parties, Millard, is for the unfinished work of that tender. And the claim in suit B is, Millard, the balance price between, Millard, A tender and the B tender. Because if you're one of your constituent is a member of JV and, Millard, that constituent has taken the tender at rupees 19, wherein the first tender was for rupees, say, 16. So 3 rupees is the claim in the second suit. So the tender must be different, may be different, but the cause of action is inflowing from there only. It's the balance differential price between A tender and B tender and A tender. So that is the second suit in question. So that is my contemplation of urgent relief. There we could not file the written statement. It proceeded for ex parte hearing. We have a right of cross-examination. So, Millard, naturally, I could not file, Millard, a counter claim there. So it's a nature of a counter claim with, Millard, additional reliefs of interim reliefs I have prayed here, Millard. I can file a cross suit. I can file a counter. This is all, Millard. So tender may be different. My learned friend was hinting. Parties are the same. Place of contract is the same. Job description is for the balance work, like risk purchase. So, Millard, my claim is that. Now, Millard, if your lordship takes this,
Mr. Ghosh, is your claim for the earlier contract or the subsequent contract?
Millard, my claim, Millard, earlier contract and subsequent contract taken together, it's a differential amount. I told Millard, earlier contract, the work has to be done at rupees 19. The new contract has been taken by one of the constituent of the JV who said it's not possible to work, who has left the work at rupees 24. My claim is for rupees 5.
Yes, for the differential amount.
For the differential amount.
That's for the second contract.
For the differential amount, second contract has to come in. Formula is the first contract in question.
But the
mother is the first contract.
Mr. Ghosh, the consideration of the second contract is for the differential amount.
Is a differential amount and
the entirety.
Yes, not the entirety. And there are other claims.
Matter of two contracts.
Yes, and I have a claim.
Parties are the same.
Yes.
The site is the same.
Absolutely.
But the subject matter of both the suits are different.
Subject matter of both the suits are same because the breaches of, Millard, the first contract has culminated into, Millard, the second contract. It's the balance work.
That might give rise to a cause of action of this suit.
That's arising out of. If
Millard, subject matter is a different.
If I cannot keep the first contract aside, I have annexed 2 contracts in question. My claim is arising.
So that is a different thing.
So, Millard, the site is same, parties are same. Millard, if I don't have the first contract, I don't get the balance contract. That's my case. He's working in the second contract. My claim is what? You have taken more from me in respect of the second contract.
When the earlier contract was terminated?
Millard, the earlier contract was terminated. May I, Millard? I just take it out. Or if in later, I just come give the dates one. Millard, now, Millard,
your juniors can
yes, kindly take read paragraph 74 with me. This is the way out. And this is exactly taken, Millard.
Yes.
It is noteworthy, para 74 of party, My learned friend must have placed it, my lord.
Yes.
It is noteworthy, 74. It is noteworthy that section 12A provides for bypass and a fast track route without the moment taking previous time of court. At this juncture, it must be immediately noticed that the lawgiver has in section 12A provided for pre-suit mediation only in the suit, comma, which do not contemplate any urgent relief. Next, therefore, pre-institution mediation has been mandated only in a class of suit. Next, we say this for the reason that the suit which contemplate urgent relief, the lawgiver has carefully vouchsafed immediate access for justice as contemplated ordinarily through courts of law, carving out the class of suit and selecting for compulsory media, harmonizing with the attainment of Lord of Justice.
This is the object behind 12A.
This is the object
Behind
behind
12A.
So contemplation is contemplation of the plaintiff. For that contemplation, he has to either file an application giving particulars why it's urgent. It may be allowed, it may be disallowed. Will a defendant has a right to contend, it is not. But will not contemplation from the standpoint of the plaintiff itself. That's Millard clarified, right Millard from Jamini Monor to Dhanbad Fuels. Dhanbad Fuels clarifies more, not from the defendant, from the plaintiff. And we ask for dispensation. Reading Dhanbad Fuels in para 74, I find myself, Millard, subject to correction, Millard, by this court. Even dispensation is not what you need is to file an application saying these are the urgency A, B, C, D, E, F, G, H. I cannot masking and camouflaging what? I have a cause of action which in garb of falsity and deception. Both are taken together. I have to plead my case. It is ultimately for the court to grant me on that. I cannot suppress and get 12A. I have to plead a date. I have to plead a cause of action. I have to explain the cause of action and I have to get the relief. From the standpoint of at the limited window for revocation is Jamini Monohar, falsity and deception. That's all. Where is the case of falsity and deception? That is not a case even pleaded in 12A revocation. And our division bench, Srishti goes one step further. If you want mediation, you have to say why you want mediation. And the terms of the mediation you have to do. Now, Millard, kindly have a look at para 100, which clarifies more, Millard, para 100 of this judgment. So I don't read from Dhanbad Fuels, I read it from here. My learned friend has read paragraph 9.3. I have no dispute with the proposition, nor I can have that 12A is mandatory for the class of suit which did not contemplate urgent relief. Because Patil makes it clear.
There is, Mr. Ghosh, there is no dispute.
Kindly take 100.
From this judgments, there is no dispute to the fact that it is mandatory. There is also no dispute. 12A is mandatory. There is no dispute. Mandatory in case of suits which do not contemplate urgent relief.
Yes. In fact, Patil is not a ratio for such purpose because Patil, money suits were filed without any injunction application. That is Patil. That is all Patil. Dhanbad also same thing. Suit file, no interim application. So where is your urgency? Srishti, suit file with interim application dismissed at the threshold. So the division bench said he had filed an application.
Money suit.
Both. Srishti is also, these are all money suits.
Your suit is a money suit.
Dhanbad money
What
suit.
is the injunction you are seeking?
Without attachment and without injunction, he's a injunction not to operate the bank account. And I've given particulars in my order 13. The learned judge
not to operate the bank account. What is the effect of that? That's really attachment.
Attachment. I have prayed for it.
So there is no scope for injunction in a money suit by form of attachment.
And it can, Millard, one Millard Justice Jyotirmoy Bhattacharya's division bench is there. That's an exception. And Justice
only one decision,
yes,
as you have rightly said.
Now, Supreme case, Millard, the recent one in the execution case, Millard, it has said, Millard, in a given case, you can a money suit you can give.
What injunction? Injunction for what?
Form of not to sell alienate, even outside property.
That is in a form to protect your degree.
I say so. It's a JV. JV doesn't have any assets. You give me protection for the time. This is my pleading. That's there. Now, Millard, you have to go by my pleading, Millard. It's a Order 7, Rule 11 test, Millard. Documents you can see in case of falsity. Now, kindly have a look at 100, Millard. Then I go to Dhanbad Fuels and Srishti and I end, Millard. In the case before us, suit do not contemplate urgent interim leave as to what would happen in the suit which do contemplate urgent interim relief, or rather the word contemplate or urgent relief, we need not dwell upon. The other aspects raised about the word contemplate is that to say can be the attempt to bypass statutory mediation under 12A by contending that the plaintiff is contemplate urgent relief, which in reality it is found without basis. Now, Millard, kindly take the next one. Section 82, which Lordships asked me, naturally Lordship has read it, permits the suit to be filed where urgent relief is sought for by seeking leave of court. The proviso to section 82 contemplates that the court shall, if after hearing the parties is satisfied no urgent or immediate relief needed to be granted, return the plaint for presentation to the court after compliance. Our attention is drawn to the fact that 12A does not contemplate such a procedure. So, Millard, return or dismissal.
My question to you was not that. My question to you was, what is the object of section 80?
I cannot, Lordship, I understood.
So
This is the matter.
this was not that. That is the distinction.
That is there in para 60 onwards.
Yes. So the object is both that you need not, before coming to the court, approach the authorities in 80.
And
if they give you the relief.
They did the right thing. They did the right thing. They went to mediation. ECL missed the bus. One day only, it did not. If Millard, what would happen in mediation, we do not know. Now, Millard, kindly take. It's a matter which may engage attention of lawmaker. Again, we reiterate, these are not the issues which arise for consideration. In the facts of the case, admittedly, there is no urgent interim relief contemplated in the plaintiff. Now, Millard, Dhanbad Fuel says, plaint para 25, that application aids Millard, the court to Millard give Millard the exemption of 12. That's Millard say, plaint, but application is not necessary. But if you file it, it aids the court to give you better particulars there. That's Dhanbad Fuels. Kindly now look at Dhanbad Fuels. Nothing new has been said, Millard. Now, Millard, kindly have a look at the Dhanbad Fuels.
Dhanbad Fuels is in this compilation.
In the compilation,
Yes.
Yes. Kindly have a look at the Dhanbad Fuels.
Page 103.
Yes. Page 103. If you, I'll be very, very short, Millard, because Lordship, my learned friend must have read it. Millard, Dhanbad Fuels was a case which was pre-party and went from Calcutta, from Justice Shorka's order. Went from Calcutta. Now, Millard, where the suit was not dismissed since the infrastructure was not there. Now, Lordship, para 36, Patil has been quoted. Ratio of Patil. Now, Millard, kindly, Patil automation is quoted. Para 39. The position of law is well settled. A plaint may be rejected under Order 7 if the conditions specified therein are fulfilled. A decision of Patil is quoted. Now, Millard, straight away come to paragraph 42. Has Lordship found para 42? Further, it is pertinent to note that 12A of 2015 Act does not contemplate leave of the court for filing of the suit which contemplates an urgent relief, as it's clear from the word used in the provision. The provision also does not necessarily require an application seeking exemption if a suit is filed without pre-instituted mediation. Now, Millard, an application seeking waiver on account of urgent relief setting out the grounds and the reason may allay a challenge and assist the court. So you can also look at the application in the question. Now, Millard, kindly take. But in absence of any statutory mandate or rules by the central government, an application per se is not a condition under 12A of the 2015 Act. Pleading and oral submission would be sufficient in ordinary course. So my oral submission is sufficient.
So according to you,
I have it, Millard. Kindly have a look at. I have the application with me. Because our court's view was, naturally it's a jurisdictional high court, you have to, Millard, aid it with an application.
So according to you, even if the plaint is silent on the urgent relief.
Here is not. But if it was silent.
I'm a hypothetical case. Even if the plaint is silent.
I can file an application.
So if you file an application under dispensation saying these are the.
So many plaints. I have drawn few plaints, my learned friend, Lordship has drawn also few plaints. Has ever we pleaded, my lord, urgency in the plaint? We plead urgency in the injunction application. We plead cause of action in plaint. My lord, civil rules and orders, and whatever we have Atkins form or my lord, Moga's law of pleading, we plead a cause of action. We do not plead urgency. But my lord, times
So
have
this
changed.
application has not been annexed here.
No, application, my lord, has not been annexed here. I have
not been served.
This
That
is
was
the-
done on the first day.
first day
when
no
I was
served
not there.
These applications are on the
So I
first day
cannot
with
be-
the plaint.
No, but you must have got this, Mr. Mukherjee.
Kindly
Subsequently, you have not
He
got.
could have got. He could have got.
Have Milord is something else.
This
Milord, we
cannot
filed
be
an
served.
application.
It a 4-volume
Invocation.
civil revision application. This is the only relevant document that is missing.
No, that has not been served to us. Milord, we have
not
consciously
normally served.
in the application
Therein
for
the
revocation of leave, we have
If
taken
he had
that block.
asked me, I would have given.
That is asking is something else.
I would have given. Where is
Yes.
this? Kindly look, Milord. I say, Milord, this is Milord. Para
No, please give a copy to Mr. Mukherjee.
I have.
You have got. Yes.
Actually, he also knows in lower court, Lakshmi 45 is a judgment of our court, says you file an application. So we are filing application. Millard kindly took the applicant emphasizes the urgency in the filing suit without undergoing pre-institution mediation as indicated by the failure of the institution mediation process in the earlier suit. B, advanced stage of TS commercial 14 of 24 is now fixed for arguments. Irreparable harm and injury would be caused if defendant suit is declared within the appellant's counterclaim being adjudicated. Next, the applicant forbids a decree in favor of would result in a significant loss to the public exchequer as the claim made by the disputed and potentially fraudulent. Now, Millard, next, suit contemplates urgent relief, and I've given Millard full particulars. It's a JV, it's going to go. It's more or less, Millard, in the line of paragraph 25. I have given particulars.
No, where is the urgency pleaded? Here,
Paragraph
urgent. 12.
Suit contemplates urgent relief. Defendants have already filed the suit. I've given.
The suit contemplates urgent interim reliefs.
Yes.
The defendants have already filed a
Yeah,
suit
place it.
against
Millard,
the
kindly.
plaintiff and
Moreover,
is
the
numbered
defendant
as
is a joint
in
venture
respect to the
special
parties have
wicket,
explored the possibility.
reasonably believes. Millard, Lordship reads the full.
There
I've
are
given the
appropriate,
fullest
the
details.
plaintiff has advised to take reliefs claimed for in this may become.
I have seen why mediation will not be successful, why I want, I have filed an application. It is amplified. Plaint is there in the body, it's amplified. And the learned judge takes my petition of the plaint to be correct and permits me to file a suit. I don't even say dispensation.
Yes.
Like explaining a section 5. I have told Millard in one of the matters that it's like what has now happened in a plaint, you have to explain like a section 5. If that is the position in law, we have to do it. Normally, earlier plaints 4 pages. Now, Millard, plaints commercial matter 55 pages minimum.
That is because you plead evidence in the plaint.
We have to annex
Evidence did
documents.
not be pleaded, Mr. Ghosh.
Millard, in commercial,
only
yes.
Evidence.
Yes, all documents have to be annexed. Purport of
Documents have to be annexed,
What
but
do I
evidence
say?
did not be pleaded.
What do I say? I have to explain the documents. Can I annex without the terms of the document?
Explanation is not necessary. That's not pleadings. Explanation may not be necessary.
My plaints.
That's your argument. That's your interpretation. That's not
More
pleading.
you plead, you cannot swing the case, Millard, in the final hearing. You get stuck. Now, Millard, kindly take us 42.
42 of?
42 of Dhanbad Wells.
Paragraph 42. Yes.
Paragraph 42.
Yes.
Now, Millard, Jamini Monohar has been explained. The court in Jamini Monohar versus KD Thirid reported in such and such while interpreting the import of an expression, a suit which does not contemplate any urgent relief. Use section 12A to be observed that the word contemplate connotes deliberate and consider. Further legal position that the plaint cannot be rejected and entertained reflects the application of mind by the court as regards the requirement of urgent relief. The court further observed prayer for urgent relief should not act as a disguise to get over the bar of section 12A. However, at the same time, court observed that mere non-grant of, which my learned friend said that interim order of ad interim, ad interim stage when the plaint is taken up for admission and examination would not justify rejection of the plaint under order 7 rule 11 CPC as an interim relief is at times also granted after issuance of notice. Further, even after the conclusion of argument on aspect of interim relief, same is denied on merits. That would not by itself justify rejection of the plaint under order 7 rule 11. Now, these I have placed. Kindly straight away come to paragraph 44. This I have already placed in the morning from the impugned judgment. Thus, it is clear from perusal of the aforesaid decision, the test under 12 is not whether prayer for urgent relief, urgent inter actually comes to be allowed or not, whether on an examination of nature and subject matter of suit and cause of action, and the prayer for urgent interim relief by the plaintiff could be said to contemplate in a matter seen from the standpoint of the plaintiff. So you have to put yourself, any honorable judge, from the armchair of the plaintiff.
No dispute because it's only the plaint.
Only the plaint.
As in order 7 rule 11 also.
So now the exception is carved out. Falsity, you cannot make false statement and get that. You can make delay, you can explain, you cannot explain. But what you cannot do, you cannot suppress fact makes false statement. That's clarified. Jamini Mono right up to our court.
Yes.
Further, what has to be seen, keeping in mind that the court is that urgent relief must not be merely unfounded excuse bypass the requirements of 12A of the Act. So it should not be unfounded. Now, in case A between party AB has not resulted in mediation, whether it is unfounded or not unfounded. Now, straight away, takes paragraph 57. Or Lordship will straight away come omit that. Kindly have a look at straight the conclusion part, para 62.
Yes.
The decision of party automation lays down the correct position of law as regards 12A of the 2015 Act by holding to be mandatory in nature. No dispute, Now, kindly, B, C, we are not concerned. D. A suit which contains urgent relief may be filed under without first resorting to mediation as prescribed under 12A of the Act. Now, this D has to be read with E. Unlike section 82 of CPC, leave of court is not required to be obtained before filing without complying with section 12A of the Act. So I don't require any dispensation also. I will say to the court will grant. I have to have an interim application for that. Next, the test for urgent relief is on examination of the natures and subject matter of the suit, cause of action, prayer for urgent relief by the plaintiff could be seen from this, could be said to be contemplate when the matter is seen from the standpoint of the plaintiff. G is the caution. Courts must also be wary of the fact that urgent interim relief must not be an unfounded exercise to bypass the statutory mandate. E, even if urgent interim relief, it doesn't matter. So that's not the case in question. Now it's settled. So I don't even require a relief if I contemplate an urgent interim relief. And the contemplation is on the plaintiff. Lordship has to see falsity, deception, malafide on my part. Brother Dhanbad he makes it more, shrinks it more. Patil is some places is doubtful. If your Lordship asked me, Patil was doubtful. But Patil paragraph 74, no one reads. My learned friend has read quite in detail the judgment. 74 is the way out. Para 74. And 74 and 100 are the way out. Look, you are not considering the issue. Even Srishti says the same thing. My learned friend must have placed Srishti. Just takes 2 paragraphs from Srishti and 2 paragraphs from my plaint in question. Kindly have a look at Srishti That's
First judgment.
First
compilation.
Yes. First compilation. This was a pure money suit.
Yes.
Srishti was a pure money suit which Lordship can file, It's a pure money suit in question. Now, kindly have a look at paragraph 19 onwards. First part I have omitted.
Yes.
Under section 12A, a cooling period is provided for the parties to explore mediation. When a suit is dismissed under Order 7, Rule 11, fresh suit can be filed, but the court fee is payable over and again. When under 12A, the plaintiff is compelled to go to mediation, there is a ray of hope that the matter may get settled. It's a win-win for all parties if the mediation is successful. Now, my lord, para 20. In paragraph 92 of the judgment, the court proceeded to analyze the point which could be said. Now, my lord, kindly take para 22 straight away. What the party did not decide. Now, my lord, para 24. A case where the defendant has no intention of resolving the dispute by mediation. In fact, he is fiercely opposed to any claim by the plaintiff. When leave is sought to file the plaint without pre-litigation mediation, such leave is granted. He immediately makes an application for revocation of the leave on the ground that the plaintiff ought to have, but did not undergo pre-litigation mediation. No urgent relief was contemplated.
In your case, can it be said? Paragraph 24.
Yes, Lordship.
Does it apply to your case?
Well, he hasn't said so.
Because the defendant, if you are saying that the defendant has filed a suit,
yes,
and approached the mediation failed,
yes,
so the defendant is always willing to go for mediation. So does 24 help you, or it's
the
against?
defendant in this suit, my lord, should have said so.
If you are relying on the other suit,
yes,
in a roundabout way,
it's absolutely.
So here 24 is against you.
Yes. Now, my lord, 24 defendant. This is, my lord, one of the
because
cases.
the defendant here, as a plaintiff, he went.
He
so
went.
he's all along. If you are taking the help of the earlier suit mediation,
there are
so
two
here
things.
also 24
Yes.
cannot come to your aid.
Yes, Millard, there are two things. A, Millard, either Millard, there is a cross suit buy-in between the parties. That is one of the ground for exemption. Second, Millard, it's a question. Lordship ignores the first suit in question. Then, Millard, intention to mediation in this suit should be there also.
No, there are two ways. You cannot take both.
I cannot
one,
take
one
I have
say,
to choose one.
yes, you have to choose one.
Millard,
when you are saying yes, that failed, so I did not. If you say so, 24 is against you.
Yes. Now, Millard, kindly, Millard, takes Millard paragraph. Then, Millard, Lordship will read paragraph, Millard, 28 for my lord's reading for the another matter I don't place. Now, Millard, viewed with suspension, etc. Now, kindly take Millard para 29.
Yes.
Let us look at some decision with this regard. The meaning to be ascribed if a suit contemplates urgent reliefs, a division bench of this court in Gabriel versus such and such remarked. The legislature, in my opinion, has used the expression contemplate to express the intention to an interim relief that may be required at the time of filing the suit or may be required if I express the intention to act to defeat the decree to be passed. So, Miller, this was the finding. Test it with paragraph 25 of the plaint. So the test, in my opinion, is not an urgent interim relief immediately required, or whether the averments in the plaint stand to the situation even before expiry of 3 months. The plaintiff have the need for urgent interim relief. Now, Millard, Jamini is quoted. Lordship will kindly omit that. Millard, next is the explanation of the, or Millard, what the division bench played. Clearly, Supreme Court established the standard against which the plaint and the application of urgent reliefs have to be tested, amongst other, on the grounds. 1. Commercial court has to examine the nature, subject matter, cause of action, and the relief sought. B. The facts and circumstances have to be considered holistically from the view of the plaintiff. The plaint, documents, and facts should show and indicate urgent relief. Therefore, to dismiss a plaint, a commercial court has to take a thorough examination of the case while looking at the deception and falsity. Nothing new. It's Miller reproduction of Jamini Monohar. Next, the plaint cannot be dismissed at the threshold for failure to prima facie establish urgency. Say the plaint in a simple money suit, it's likely to be noticed defendant might start disposing of some of the assets. A decree might have been passed against him, so that plaintiff may contemplate urgent relief for an attachment before judgment, but need not plead it in the plaint. Here it's pleaded as a cause of action has arisen at the time of institution. Please note, the word 12A, the legislature does not mean plaint. It uses the word suit. It employs the word contemplation. Hence, it avoids the word averments or statements in the plaint. In the other words, legislature does not say that the statements or averment in the plaint, urgent reliefs obtainable by the plaintiff, should be apparent. I would interpret the section as suggesting as a fired at the time of presentation of plaint before the judge on the averment of the plaint and an affidavit to be filed by the plaintiff, it would appear that the contemplation of the plaintiff a situation for urgent relief might lie within when mediation has undergone. The court may allow the plaintiff to without mediation. On basis of the declaration, urgent relief plaintiff should be allowed to present the plaint.
You can come to paragraph 34.
Yes.
That is in your favor.
Yes. The learned judge should have, yes. In this case, although the claim is monetary, there is pleadings and still defendant is incurring heavy loss at the time of interim reliefs may be sought for. The learned judge should have accepted the averment and allowed the plaintiff to institute the suit without 12A requirement. Instead of the learned judges tried to prove in the ambits of
So
the
this is monetary, so losses, that's your pleading.
That's my pleading. Lordship has to go. Now, my lord, just takes my lord 2 paragraphs. Now, my lord, listen to NHO. And from this, my lord, over enthusiasm, my lord, get a copy. What? Special leave petition. It was not entertained.
So special leave
petition
of against this.
Against this. This was not entertained. So findings must have been challenged there. On view of Jamini Monor. So this is not the right interpretation of Jamini Monor.
Special leave petition, Mr. Ghosh.
This is not a merger.
Not a merge.
I know that. But Willard, it was not upset by the Supreme Court. It was not upset. It holds its peace. And Gabriel is part of it. Now, if your lordship takes my plaint once, because this is the most vital question, lordship, what is my case in the plaint? If your lordship takes the plaint once, volume 3.
How much time you will take?
More or less completed. Or what, Willard? If your lordship, 10 minutes tomorrow, for 10 minutes, 15 minutes.
10 minutes you will wrap up.
10 minutes tomorrow we come, Willard.
10 minutes today it can be.
1 minute, then I wrap up, Willard. I don't want to carry it forward. Again,
because I have only to rise 10 minutes before 5.
Very well. No different judgments, nothing more. If there are 3 Supreme Court, 2 division benches, I need not cite Willard the single benches, those I have given it. Those are not necessary. Those are all following Jamini Manohar, and 1 case I have given Willard, where Willard the suit was dismissed, but Willard this on the ground of falsity and deception. That is Justice Kapoor's bench, Willard. Yes. Which I had argued that only this is the window and this window should be pressed into operation.
Yes.
Now, Millard, kindly have a look the plaint in question if your lordship takes the plaint.
Yes.
Millard, it's page number 322 of your lordship's brief.
322, yes.
It's Millard, it's 315. Now, Millard, kindly have a look at paragraph 3. The plaintiff states the defendant numbers 1 and 2 together formed a joint venture. MMPL such and such has participated in the e-tender of the plaintiff dated such and such, loading crusher annexed here. Now, Millard, kindly take successful bidder. What happened to the earlier contract in question? Now, lordship will straight away come to para 17.
17.
17.
Yes.
The defendant contractor could not complete the total awarded work within the time specified in the NIT and has failed achieving the said quantity. The plaintiff's company, finding no other alternative, was to float a new tender for completion of the unexecuted quantity of, that's the unexecuted quantity of the original tender. 20 such and such. The work was allowed NKAS, who was one of the partners of the earlier joint venture consortium. So this is my case. NKS was one of the plaintiffs in an earlier suit which has been filed by the defendant, has emerged as the successful bidder of the subsequent fresh tender for executing the balance work. The rate at which obtained the work is much higher than the original agreed between the plaintiff and the defendant. The previous rates for executing the work are ₹19 and subsequent balance work is 25. It is surprising NKS, even after purporting to complain that raise allegation, etc., hindrance, they have got the tender. Willard calculation paragraph 19. And Millard, para 20, as one of the contractors is NKAS is already executing the same work at a higher rate, defendant cannot complain of any damages, loss allegedly suffered by them for executing the previous work. And Millard, I have given the particulars and I have claimed reliefs in the plaint.
Where is the application for interim relief?
And application for interim relief.
Have you annexed?
Yes, 446. 446. Prayers are 452. The honorable judge, my junior moved it. He said that I can give you leave, but no ex parte order, since parties are already before me. That is filed on the same day itself, my lord, along with the plaint. Right? It's filed along with the plaint. Because Justice Krishna Rao has passed a practice direction here, my lord, in commercial division, that, my lord, in this suit, my lord, it will not come on board or urgent relief dispensation. You have to have an application together with it.
Yes.
So I have filed it. On affidavits, I'll get an order. I hope so. If I don't get an order, it may not be a ground. I have to file an application in aid of the suit. And why I filed it? Because it's a JV. JV normally doesn't have assets. So I have filed it. So, my lord, in this scenario, my lord, 12A perhaps, my lord, cannot be, my lord, revoked, my lord, since already the parties are before the court and one set of mediation has failed. So these are my respectful submissions.
Yes. Just to sum up, my lord, my learned friend has said that with regard to the application, interim application, this can also be looked into according to my learned senior friend's submission. My lord, perhaps, my lord, partial automation, paragraph 100, my learned friend has placed the last portion of the paragraph 100. It has been clarified that it has to be on a bare reading of the plaint. And
Dhanbad,
I will come to Dhanbad also.
Yes.
My learned friend
There it has been said from the
And-
reading of the
yes,
plaint.
that is.
I read and I leave and follow on paragraph 25, my lord.
Very well, I will.
Let the plaint.
Yes, it's clarificatory only. I cannot argue.
So according to my learned friend, the class of suit is different, like a commercial suit. He has to plead even the evidence and other. Not your lordship knows the commercial suit texture of the plaint is quite different than that of a pleading made in the suit under section 9 of the Code of Civil Procedure. We all know that. That's why even adjournment, order 9, rule 7, everywhere there is a class of change. So they will have to conscious. Even something more is to be pleaded, some more verification is to be made. There's a the class. So if that be so, 12A is also creating a bar. You have to do something in your plaint. And it is the connotation of suit explained in partial automation, that paragraph 100, that it has to be bare reading of the plaint. Kindly read on. My learned senior friend has as if said, Jamini Monohar is creating a falsity and deceptive. This is the only one window. For that, only the rejection of plaint can be made. Otherwise, not. Whatever the pleading, whatever the urgency you plead, that has to be go only falsity and deception. In my respectful submission, exactly what not has been said in Jamini Monohar. That is one of the possible eventuality. Paragraph 12 is not that. Only in respect of falsity and deception, the 12A can be revoked and no other case. So, if nothing has been suppressed and on merit the court is of the view, no, your urgency is camouflage, this cannot be done because no falsity or deception. I have pleaded everything. So even if I plead, my cause of action is 2023, court has to give me leave because I have not given any false statement. That is not the law, my lord. On the contrary, Jamini Monohar, paragraph 9, the judgment of Delhi High Court is being quoted. I referred before your lordship, paragraph 3.4, 3.5, where the Delhi High Court, not page 9, Lord, I'm sorry, page 819.
Yes.
Internal page.
Yes.
Paragraph 9, it has been quoted from the Delhi High Court that 3.4 and 3.5, it is solely on the frame of the plaint and the relief shot. Answer is being given, my lord, also in Jamini Monohar at paragraph 12. Because this is quotation, I cannot rely on it. Paragraph 12, the answer contemplation, which means the plaint. So, my learned friend's contention that I will come to paragraph 42, my learned friend placed, as if the other interlocutory application can be gone into.
Yes.
But Jamini Monohar gives an answer
Jamini Monora says that, but he is on Dhanbad field.
I'm coming. Immediately I'm coming to that. So paragraph 10 and paragraph 11, if we read conjointly, the Honorable Supreme Court saying 12A is mandatory. Falsity and deception is one of the eventuality, that is not the one window only. Now kindly takes up now my learned friends contention with regard to the Dhanbad fuels. Kindly takes up paragraph 42, whether it inures to his benefit. Rather, it clarifies that no interlocutory application needs to be gone into, because it's a provision appended to the statute for which you don't have to seek for leave. It is the duty of the court to look the plaint and thereafter to pass an order that whether you have to, the plaint has to reject it on that score, or this contemplation is there in the plaint, so the leave may be granted. Further, may I place paragraph 42? Further, it is also pertinent to note that 12A of 2015 Act does not contemplate leave of the court for filing the suit, which contemplates an urgent interim relief. As it is clear from the language and words in the provision. The provision also does not necessarily requisite an application seeking exemption in a suit in being filed without pre-institution mediation. An application seeking waiver on account of urgent interim relief.
What is the meaning of this?
I'm coming, Milord. I'm coming. This has been explained in the subsequent sentence. An application seeking waiver on account of urgent interim relief, setting out grounds and reasons may allay a challenge and assist the court. Next is very important. But the absence of any statutory mandate or rules made in the central government, an application per se is not a condition under section 12A of 2015 Act. Pleadings on record and oral submission would be sufficient. So again, restricted to pleading. Pleading.
But Mr. Mukherjee, it says both ways.
But then also I will come. Your Lordship has seen, Milord, I for the first time have shown this seeking leave application. Paragraph 10. They have seek for the entirety of failure of pre-institution mediation. Kindly comes to one page. I will rest my case over here. Kindly comes to page 281 at volume 2, Milord.
21, volume 2.
Volume 2, yes. Volume 2, page 281.
281.
As fallen from your Lordship, Milord, I will just rest my case over here itself. It's a very nice ploy. When I filed a suit, I instituted a pre-instituted mediation.
Yes, 281.
Why it has failed, Milord, kindly see. If the defendant in that suit chooses not to appear, so, Milord, I know, Milord, my learned friend now wants to interject me at this juncture. Yes. Milord, আমি কখন বললাম দাদা আপনি বলেননি? 281 kindly see.
Yes.
Why the mediation failed? So he chooses not to appear, mediation fell there. And this will be a ploy. He will say, once that mediation fell, so there is no necessity for going into the mediation because the parties are fighting. Why the parties are fighting? Because of you. The law says you have to do that. You are saying, taking aid of that suit, I will not do this in my suit. Whether this can be a ploy. If this is a ploy, Milord, then section 12A has to be negated.
Anything more?
Send both parties to mediation. Send both parties to mediation now. This can also be done under it.
This, Milord, after Milord 2025, Milord, this cannot be done.
Can be done, Milord. There's
The paragraph I have
new one.
shown.
There's a new one, Milord. It can be done. There's a Milord direction coming up from direct practice direction. I did not present both them to the mediation. Nothing, Milord.
Want to file written notes?
Short written notes. Because
if your Lordship's required, otherwise I don't
file it. I think it's necessary.
It's necessary.
25th is the date fixed before the trial court. So, Milord,
25th.
It matters, Milord. We are fighting, Milord. It is a stage where the suit
I'll
can
file it within that date.
within that day, Milord,
I'll
yes,
file
yes. Back to that I shall file.
25th, what happens?
25th July is the date fixed.
For injunction application hearing. Nothing else. I'll take adjournment then. More difficult.
Giving
the judgment, my lord, we may not, my lord, again.
Then, since you are filing the written notes, I will request both of you, any of you, not both
I'll
of
take
you.
back, my lord, whatever I have not cited.
No,
Whatever I have not cited from this spiral, I will take back.
you can do that, but some I have marked.
No,
That's
your
the-
lordship's mark, your lordship.
Or mention in your written notes.
The
which you
paragraph
have-
numbers.
Which you have cited. One second is any of you give me a compilation of the plaint, not the annexures. Plaint, injunction application and that leave application.
My lord, only plaint
Only the plaint, no annexures.
of both the, my lord.
Because annexures are there, it's difficult.
Your lordship is required the plaint of the present suit.
Yes, yes, plaint of the present suit, not the earlier one.
And my lord, that
Plaint, injunction application, 12A.
12.
No 12A leave revocation or
Yes,
objection.
yes, that order is there, that I will give.
No,
Application.
revocation application was filed.
Yes, yes.
Then give me a copy of the revocation application.
So, my lord, this,
No annexures are necessary. Please don't make it this one.
no, my lord, only plaint up to affidavit page clarify, and my lord, the revocation as
Only up to the affidavit page,
application
only the
for
body of the
injunction.
applications.
Yes,
It's very
application for
difficult to
injunction.
go through
CL
this
is,
to handle
CL
this.
is very happy to do mediation. Why on the first day, my lord, here, my lord, mediation, at least 4 notices are given, my lord, in Kiran Shankar Rai Road, my lord, which I once went once. 4 notices. I used to go defend. Last the defendant came, my lord, in the glass box matter, my lord. Where one day, my lord, I do not know why they closed the mediation in district court. Rajarat also, my lord, one day miss gone.
Thank you.